Committee Room 8, sound.
Order, order. Welcome to our fourth public evidence session, and welcome to Mr. Pickles, Mr. Killock, Ms. Robinson and Ms. Patrick. And for the record and for the benefit of the public who may wonder what's happening, Mr. Pickles and Mr. Killock were giving evidence last week. We didn't manage to get through all the questions we wanted to ask of them, so we've added them onto today's session. However, we'll ignore them for the first few questions because we have a few questions we'd like to put to Ms. Robinson and Ms. Patrick first, if we may. Could I start, therefore, by asking each of you, Ms. Robinson and Ms. Patrick, to outline your main concerns about the proposals embodied in this draft bill, and what are the areas which you each hope this joint committee is going to consider?
Well, I'll make a start. Liberty are, of course, incredibly concerned about effective law enforcement, and particularly, the need to protect the public from serious harm. And we've never opposed targeted surveillance based on individualised suspicion. But what we have here is really a far cry from that. We have concerns about all areas of the bill, but really the core of our concerns and the fundamental shift here, it flows from Clause 1 and flows from arrangements for collection of communications data. Communications data is already unique in terms of its historical availability to law enforcement agencies. And whilst other countries across Europe are challenging the constitutionality of arrangements as they stand, we're finding ourselves in the position of pushing for a real sea change, a real step change in terms of the arrangements for collection of communications data. Never before have private companies been called upon to collect data which they have no business purpose to collect, purely on a just-in-case basis to satisfy potential future arrangements. And we hope the committee will explore what we identify as the three fundamental assumptions and flawed assumptions upon which this policy is based. So firstly, the idea that communications data is in some way not particularly intrusive or not particularly revealing. We argue that it's incredibly revealing in the current technological environment. Secondly, this idea that it even makes sense to draw the distinction conceptually between communications data and content this time. And thirdly, this idea that there will be seamlessly, law enforcement gains will seamlessly flow from these provisions, and we would suggest that the law enforcement case is at best shaky and incomplete, and we hope the committee will have an opportunity to examine these assumptions.
Right, thank you. We'll wish to come back shortly on your assertion that countries across Europe are challenging it, but I won't interrupt the flow just now. Ms. Patrick.
Hi, this is all going to sound very familiar now you've heard from Ms Robinson and Mr Pickles and Mr Killock, but Justice has worked on these issues for decades. We first reported in the 1970s that we were really concerned that we were racing headlong into a society where technology was advancing so quickly that our privacy laws were not keeping pace. So it's I'm new to my organisation, but these arguments are not new to us. But we'd like to begin at the outset by saying Justice recognises that surveillance, in many cases, is essential for the purposes of the prevention and detection of crime. And in many cases, the work of police and law enforcement agencies and the intelligence services saves lives. We accept that. But actually, the flip side to that is surveillance is of a particular nature. It's accepted by everyone that by its nature, it imposes restrictions and interferences on individual privacy of different degrees of severity. But the starting point is that it does engage our individual right to privacy as it is protected not only in the European Convention, but in the principles of our common law that stretch back centuries. So those are the two flip sides we'd like to start the committee off with. The legitimate surveillance is legitimate, but it does engage privacy and needs to be justified. And that surveillance by its very nature, in order to be effective, has to be covert. So when looking at the regulation of surveillance, it's particularly important for parliamentarians to be aware of the need for effective controls and safeguards to ensure that surveillance is only used in those circumstances where it's strictly necessary and justifiable. Because individuals, in most cases, if surveillance is effective, will never know it's happened, and so will never have access to an effective challenge or a remedy. So that's our starting point. Moving to the bill, and I'll be very brief because I know we've got specific questions, I'd like to put down 3 markers. Our first is that there's so much uncertainty in what this bill is asking for that it's impossible for us as civil society commentators to pick it apart in terms of trying to help you as parliamentarians understand what the real risks here are and what the challenges for the government in terms of providing evidence is. It's so open in part 1 of the bill, I'm finding it quite difficult to range our concerns, let alone ask what are the right questions for you to ask. And actually, when you're starting from a premise that what you're doing is engaging individual rights, that's really worrying. The JCHR, Joint Committee on Human Rights, has routinely called upon the government when they are looking at legislation which engages individual rights to provide information to allow parliamentarians to conduct proper scrutiny, and that clause 1 of this bill is so broadly drafted must be the first concern for this committee we'd submit. The second is, to reiterate Ms Robinson's concern, this is not about data access alone. It's about data collection. Your first 101 lesson as a lawyer being told to understand the law on privacy, particularly as it applies to the European Convention, is that every use of data is a new and interesting issue or set of circumstances for which you have to look at for justification. So here in the bill, your starting point is the new proposal on collection of data justified? Is the proposal on collection accompanied by appropriate safeguards? Are the measures for retention of that data, once collected, accompanied by appropriate safeguards? And then, and only then, do you move to access, which is almost the final question. And as we know, the proposals for access in the bill are actually based on existing law. The proposals in the Regulation of Investigatory Powers Act, or RIPA. And that's the last of my concerns that I'd like to raise in opening. Justice has massive concerns about the lack of safeguards in the existing RIPA provisions. And we think that building these vast, potentially vast, we don't know, looking at Clause 1 proposals, onto the existing RIPA framework is simply inappropriate.
Do you think RIPA has turned out the way you expected when you looked at it in the year 2000?
I think there was massive aspiration for what RIPA could achieve. But actually, as it passed through Parliament, Justice campaigned quite vigorously to point out exactly how much of a mess RIPA was going to turn out to be. It's incredibly complex. And actually, the safeguards that are on the face of the bill are relatively minimal. What you have is an administrative authorisation procedure backed up by commissioner upon commissioner upon commissioner, which Justice has done a significant amount of work on, which shows that actually the degree of scrutiny after the decisions have been taken to access data is pretty minimal. And our concern is that although the aspiration was to make RIPA post-HRA 1998 compliant, a shining example of a human rights compliant framework for surveillance, is that it simply isn't up to the job.
Mr. Brown.
Say something to us in general terms about the sort of safeguards you would like to see.
Well, I think in terms of our approach to this bill, before we get to the point of sort of considering potential safeguards, we are incredibly concerned about the path along which we are treading. It's only relatively recently that we took, a significant step back in 2009 in requiring communication service providers to retain records for minimum periods, records they already retain for business purposes. And now we're already seeing the next step, and we're very concerned about where this path is leading us potentially. To be quite frank, there is no safeguard that can allay our concerns about the kind of collection provisions set out in Part 1 of this bill. As I said in my introduction, the communications data and its use in law enforcement is a recent boon for law enforcement agencies. It's unique amongst other forms of surveillance provided for in RIPA in terms of its historic availability to law enforcement agencies, and we simply don't accept the premise, if you like, that the philosophical point that the state has the right to keep this information about people in relation to whom they have no suspicion of criminal wrongdoing.
What about where they do have suspicion of wrongdoing?
Well, we have never objected to even particularly intrusive forms of surveillance, such as bugging covert human intelligence sources, where they're based on individuated suspicion and with appropriate safeguards. Now, in terms of safeguards around access, we have consistently expressed concern around the access provisions set out in RIPA, which are mirrored in this bill. We've consistently expressed concern about internal authorisation processes, about the breadth of the permitted purposes for which this information can be accessed, the range of public authorities who have access, and these concerns are of course thrown into really sharp focus by the increase, the real difference in the nature as well of the data which would be retained under these provisions.
And is that the same for Justice?
Yeah, Justice.
Is there anything you'd like to add?
Justice did look very closely at the RIPA provisions, but before I outline our position on that, we are concerned. I mean, Clause 1 of the bill is a game changer. Could be, because we just don't know is the answer. And people are very concerned, and quite rightly, because as I say, if you're going to keep information about someone, it's traditionally been done for a purpose. It's almost beginner's lessons in the common law. We don't do things unless there's a reason to do it. And the question here is whether accessing every piece of information about anyone's use, particularly of the internet, is justified, is a big question, and we'd say it's the starting point for this committee's deliberations and must be. Now, moving on to RIPA, we've had exactly the same problems with the RIPA framework in terms of its breadth of gateway, particularly for access through non-law enforcement agencies, but also in terms of the mess and the jumble of authorisation mechanisms that exist in RIPA in terms of different types of surveillance and different types of authority who have access to different powers for different purposes, and the severe lack of judicial or other oversight of how those powers are used in practice are a point of real concern for us. Administrative authorisation is the norm for communications data access and will continue to be so, except in connection with local authority use. That's a major point of concern for us, and we just don't understand how you could expand access to communications data without redressing that balance, even if there is evidence for further expansion.
Thank you very much. I think that's going to lead nicely into what Mr. Ellis will want to ask you, but before that, I neglected to ask each of you to say who you are and where you are in the organisation, just for the record.
Hi.
So we'll go Ms. Patrick first.
My name's Angela Patrick. I'm Director of Human Rights Policy at Justice.
Thank you.
Rachel Robinson, Policy Officer at Liberty.
We'll ask you as well, Mr. Killock, to just do that bit at the moment, and then we'll ask you to be silent for a few more minutes. Yes, you are. Yes.
Jim Killock from the Open Rights Group, Executive Director.
Okay.
Nick Pickles, Director of Big Brother Watch.
Okay, thank you very much. That's that taken care of. Mr. Ellis.
Thank you, Lord Chairman. I think going back to the issues that you both were speaking about in terms of authorisation, well, obviously you say that there's no purpose that you can detect in this, but no doubt you'll accept that the police would say, or the security establishment would say, that there is a purpose, and the purpose is to help them detect offenders and for the prevention of crime and to assist them in their work to keep the country safe. So that would be the purpose that they perceive. I don't think it would be accurate, would it, to say there's no purpose to the bill. One would hope that there would be some counter-proposal to that suggestion. But if I can ask you both about your views on the authorisation system, because the draft bill has been criticised by yourselves and by others for not requiring public authorities other than the local authorities, councils and the like, to seek any independent authorisation, by which I mean people like magistrates and the like, or judges, to obtain communications data. So instead, the mechanism envisaged by the bill is for a senior designated officer within the security organisation in question. So a senior police officer, say of the rank of superintendent or the like. So do you think that independent authorisation should be required outside of the scope of each organisation? And if you do think that, how can you maintain those thoughts when we're aware that there's over 550,000 requests per year? And how would that not clog up the whole system?
Well, we think independent authorisation should be required. It's not enough to remedy the problems here, but it's very difficult to see how an independent decision can be made by somebody within the law enforcement agency in question. And we're not suggesting for a moment that there are routine sort of abuses going on or any sort of purposeful misconduct on a routine level. But what we are suggesting is that there is an organisational culture problem. So obviously if you're working within an organisation, your primary concern is going to be with the operational capacity of your organisation. And when it comes to conducting the delicate balancing exercise which takes place under Article 8, necessity, proportionality, an independent member of the judiciary with experience of weighing up these problems and principally and most importantly with the prerequisite independence, is the only authority in the proper position to take those sorts of decisions.
But if there were over 500,000 data requests, would that not be, first of all, extremely expensive, and second of all, simply not feasible because of the sheer number of requests to a judicial authority?
Well, the first thing to say, I think, is that the sheer number of access requests, which has remained at the 500,000 mark for a long time now, is indicative and just reveals the sheer scale of surveillance that's happening here, and that's just on the basis of our current arrangements, and that's a real cause for concern.
Can I just challenge you on that? Because just to come back on you, to give you the chance, we heard evidence on a previous hearing that actually, although it sounds like a lot, 500,000, and it is a large number, there are something like 25 million recorded crimes in the country. And many crimes nowadays require the use of data of this sort to be solved. So put in context and perspective, would you not say that the figure is not actually as high as it might be?
Well, there are always steps we can take to reduce crime and produce law enforcement gains. These steps could be things like, imposing a curfew on all males aged between X and Z for a certain period. There are always things that we can do which have law enforcement aims, but they're not the kind of things that we would find acceptable in a liberal society.
Okay. Ms. Patrick?
Hi, can I actually take a step back? Because I think before you asked your question, you actually made a separate point, which was you've already heard evidence from Home Office officials and law enforcement agencies and others about why they think these proposals are needed. And I'd like to clarify, of course, and I started at this point, some surveillance is necessary, some surveillance is crucial and justified. But I'd like to remind the committee that actually under REPA there are already very wide powers to access information that already exists. This is not about starting at scratch and saying, let's open up key gateways to ensure that we are helping the police solve crimes effectively. What we are really talking about is whether the proposal in Clause 1, which is to create new mechanisms for collecting and retaining new information about everybody, potentially, and anybody, potentially, we just don't know, just in case, in order to expand the pool of information that may be needed for criminal investigation purposes and may expand the pool of information that's available for those purposes, is appropriate and justified. Now, that's the real question here, not is it appropriate for the police to have access to surveillance powers for the purposes of crime prevention? Of course it is. The question is, what should the powers of data collection and retention look like in order to enable the police to use those powers at a point which is most justified? And the question is, what and how do you approach the balance between infringing the rights of those who might never be suspected of crime by collecting data about them and retaining them, and on the other side, reaching the optimum and most effective mechanism for crime prevention? And there has to be a balance there.
Sorry, can I just bring you back? I appreciate what you're saying. Can I bring you back to the authorisation point and whether you feel that there should be independent authorisation outside of the organisations, and how you marry that up with the issue of the quantity?
Happy to do it. Justice, we reported last year, and having looked at the whole of the REPA mechanism, said prior judicial authorisation in most circumstances should be your starting point. In terms of communications data, we again said an independent judicial authorisation should, in most cases, be the default. However, we did also say that we recognise, as was explained by ACPO and the Home Office when they gave you evidence, that there are going to be clearly some circumstances where there's an emergency, where there is a pressing, time-sensitive issue which requires action to happen now. And we accept that in real terms those circumstances might arise. And we've said that in those circumstances, if you have a law enforcement agency, the police or others, who are in those circumstances, we can see the benefits of having an administrative authorisation, but subject to retrospective judicial scrutiny within a reasonable time frame. And we've said 2 days or thereabouts would be reasonable.
So you would agree that there might be permitted purposes for which you wouldn't seek independent authorisation, and particular types of data? So, for example, subscriber data, just the raw fact of who is subscribing to the use of an instrument, that's not such sensitive information as other types of information.
We have said that there is a sliding scale. At one end of communications data, you are looking at subscriber data, which is your name, your address, how you're attached to your account, through obviously user data and traffic data, which becomes, we'd like to reassert, much more intrusive. And we have in our report said, in terms of subscriber data, if you were simply looking at administrative approval subject to other safeguards, that could perhaps be justified. But in terms of these other forms of communications data, user data, traffic data, we think that the default should always be, except in that very narrow band of circumstances where there is an emergency, the default should be judicial independent authorisation.
Do either of you have any evidence about any individuals who have suffered harm as a result of their communications records being accessed by an investigator?
Well, I think that the first thing to do is probably talk about the latest Interception of Communication Commissioner's report. Hundreds of errors identified even on the basis of the small sample, here accessed on the basis of retrospective scrutiny. 2 people detained and accused of crimes on the basis of inappropriate use of their communications data. And
2 people out of how many points of data access?
But we need to
hundreds of thousands?
Well, we need to not lose sight of the fact that this came from provisions which were designed or allegedly designed to keep us safe from harm, and we're seeing repercussions like this. But before we even get to that point, before we even get to errors and abuses or mistakes in terms of processing or accessing data. We need to look at the very real harm which comes from the retention of the communications data of potentially everybody resident in this country at the moment, and we need to think about where we're heading as a society, if you like. What is going to be the next step when we build an infrastructure which has certain capacities? What's the next step along that line?
Because there isn't going to be a database as such for this information, is there? The plan is to ask the service providers to retain the data for a period of time, which is not quite the same as a government database. It's not at all the same as that, is it?
Well, we'd query the conceptual distinction between several smaller databases linked together by a government-run processing.
I appreciate you'd query that, but would it not be the case that, a possibility at least, that companies could, and in other jurisdictions may well be, keeping data for their own purposes without safeguards that this bill might envisage? So there may not be a time limit, for example, as to how long they would keep data, things of that sort.
I mean, obviously there should be protections around data retention in other contexts also, but I think we really do have to recognise the step change here from a position where companies keep information for their own commercial purposes to a situation where we're effectively contracting out responsibility for keeping records on the entire population for future law enforcement purposes. And
finally, from me, anything that you feel about this bill that would be non-compliant with the provisions of the Human Rights Act? I think you said, Ms Patrick, that you were Human Rights Director for Justice, is that right?
I am. Can I simply come back on your last question before I answer this one? Is that okay? I know we're short on time. I agree with Rachel's position that there are wider implications, not simply of individual cases, about creating potentially vast storage of data. I won't repeat what Rachel has said, but I will take you back to my first point. Surveillance is particularly special, and states in the case law around human rights have been put under a particular obligation because these types of powers take place in circumstances where they are, by their very nature, covert. So people who may be subject to surveillance may never know. If they're never prosecuted, if you're somebody who's innocent but somebody's had to have a look around in your files or they've used these particular powers, rightly or wrongly, you may never know. So in fact, there's almost a higher burden on the state to look at the safeguards to make sure that they are clearly defined, strict, and designed to ensure that only those powers that are necessary exist. Because otherwise, the individual themselves are not, as they might be in terms of false imprisonment or something else, where it's pretty obvious that your rights may have been infringed, in a position themselves to seek redress. They might never know. So actually, the question about harm, as Rachel comes back to it, we've often only found out about where there's been an error, where somebody has let slip that something has gone wrong and that you've been subject to surveillance and therefore you've been able to seek some form of redress. So that's a very simplistic answer to your, has anyone ever been harmed? Well, actually, even if we do have figures or evidence of error or not so much misconduct, mistakes having been made, there's a bigger question and a much more baseline starting point, I think, for the committee's consideration. Now, moving to your second question about human rights compliance, I'm again going to say, actually, it's a sliding scale, and we've looked at REPA like this. The wider the gateway you make, the more likely it is that without some form of judicial oversight, in an individual case, if there's evidence that something has gone wrong, there will have been a violation. Now, that analysis becomes much more problematic because there's so little case law on surveillance, because of the simple fact that these cases don't come to light very often. They will often only come to light when there's been a problem, and Liberty will be very familiar with this, having recently represented a lady from Poole who only found out that she'd been trailed by her local authority because another local authority employee let it slip. So actually, the problem we see is looking at the case law. The courts have been quite robust about the fact that the best safeguard you can put in place is judicial authorisation prior to the surveillance having taken place. They have stopped short of saying you have to have this in all cases. There are surveillance circumstances where they've said, actually, you don't need a judge. But in most of those cases, it's been the case that they've looked at the facts and said, actually, all the other alternatives have been explored. It was a proportionate decision. There were numerous other safeguards in place to offset the fact that you didn't have prior judicial authorisation, including the provision for robust retrospective scrutiny. Now, we say that the provisions in REPA, which are being replicated in this bill, fall far, far short of those kinds of robust safeguards. And I'd be quite happy to take you through why we think the detail of the IPT and the Interception Commissioner structures are failing, but I know we're short on time.
Could I just very quickly add in relation to that specific second question there? We think that the data collection provisions of this bill are not, or will not be, very unlikely to be in any event compatible with Article 8. In fact, we think that the provision which exists at the moment is highly dubious on Article 8 grounds, and that's before we even get to the RIPA parts of the Act.
Thank you.
Could
we ask Ms Patrick to write to us with her views on that?
Oh, yes, on your view on the failings of the Interception Commissioner. Happy to have a paper on that. And how you think it should be toughened up and the more teeth one should have. Before asking Lord Armstrong, you mentioned in your comments that you saw a sliding scale of intrusiveness. I would really like, I think the committee would like to get a paper from Justice setting out what your idea of the sliding scale is from, I presume, at the one end, a name and telephone number of the person, through the middle ranking bits, bank account, the tracking information where they've been every 5 minutes.
We've actually produced a very hefty piece of research on it, and I'm quite happy to have copies sent to all of the members if you would like them.
Excellent. We would certainly like that. Yes, please. Could Lord Armstrong?
Thank you, my Lord Chairman. If one wanted to restrict the scope of this bill, one could reduce the number of authorities who are entitled to exercise these powers, or one could look at the purposes for which it could be made, and I want to look at the second of those. There are 11 or 12 purposes which in the bill which are taken over from REPA, which are permissive purposes for the purposes of the bill. They go well beyond national security and law enforcement and serious crime. Are you happy with that list of purposes, or would you like to see it reduced?
We've consistently expressed concern at this list of purposes, which largely mirrors that provided for in RIPA. We feel that it's very difficult to envisage a case which doesn't fall within the serious crime category, in which it would be justified to access communications data for those other purposes listed, things like the economic interests of the UK. Incredibly broad, incredibly potentially encompassing. The real potential here to go beyond what's necessary and proportionate, and to in fact attach to or apply in circumstances which do not involve criminal behaviour in any way, and that's always been a real cause for concern under RIPA, under the current arrangements, of course. Now that what we have on the table are proposals which will dramatically increase the amount of communications data and the kind of communications data retained, provisions around access are thrown into sharp focus, and they become even more of an issue.
I'm not quite sure what I'm getting from that. Do you want to restrict the purposes to serious crime, terrorism, national security?
What I would say at this stage is that it's very difficult to think of a case which does not fall within those categories in which it would be proportionate to access highly sensitive personal information about an individual. And what we would also say is the fact that the Home Secretary can amend by order the list of purposes, the fact that the purposes as they stand are so broad and ill-defined, create problems of their own, which become more important, if you like, when we think about the proposals on the table now.
Ms Patrick?
I think I'd just go back a step again. Unfortunately, like Rachel, I would say the list of purposes doesn't affect how much data is kept, collected or retained. So as a starting point, you keep everything. So it doesn't matter if you're keeping it for the purposes of crime or for the purposes of whatever. There's no qualification like that anywhere attached to Clause 1 of the bill. So basically, it's me, you, the guy you saw on the bus this morning, the person you buy your paper from. Clause 1 enables the collection and the retention of data in connection with yours, mine, his, hers, your mother, your daughter, everybody's internet usage. That all gets kept. So the first two qualifiers that I said about safeguards in connection with collection and retention and the storage of information, albeit that it's not in a government database, it will be stored in private company databases. The question is then, are there safeguards in place to ensure that that information is kept safely and not accessed for other reasons? And then the second question I would simply say is that justified? Before we get to the question of state access. Now, state access, we've already said, in order to justify accessing information, which is clearly engaging your right to privacy, the state must be able to justify it. And we can say prevention and detection of crime, etc., national security, entirely understand it. The further you get away from those core purposes, the more difficult it is going to be to justify. Now, I listened to the Home Office and ACPO's evidence, which was very full, and I understood, well, my understanding of the information you were being given from those parties is that they wouldn't like to restrict the purposes because the real belt and braces was that individuals were being asked to consider, even within those triggers, whether the use was necessary and proportionate. Now, necessary and proportionate is essential from a human rights perspective, but our real concern is, as it stands, there's nobody checking whether that administrative assessment of necessity and proportionality is right. There's no judge who's saying, have you got that right? I know that you're understanding that you really need to do this for a criminal investigation, right? Tick, that's got you in the trigger gateway. And what's the necessity and proportionality? And clearly they walked you through the training that they believe is adequate for that purpose to allow an individual senior officer to apply his mind to that balance. But at the minute, nobody is checking. The Interception of Communications Commissioner has been reporting on these issues since 2005. Now, our research showed that although the very small team of inspectors, there's only 5, look through dip sampling at each of these different bodies and how they look at communications data, not since 2004 had the Commissioner's report identified any single violation of necessity or proportionality in the decision-making of any public authority. OK, in his report last week, he found 1. Now, 1 out of 500,000 every year since 2004. Now, I'm a little bit of a sceptic, but I'm also a public lawyer who's acted both for government and for claimants. Now, in terms of administrative decision-making, no public body expects to get it right 100% of the time. And we've said as Justice, those figures must suggest that the Commissioner either doesn't see looking at necessity and proportionality as a core part of his role, or alternatively they simply don't have the expertise or the resources to be able to apply that kind of balance. And of course, applying it retrospectively in any event would only get you so far, because the interference has already taken place. We say much better to have a prior judicial authorisation, in most cases making exceptions for emergencies, where somebody who's used to applying their mind to those kinds of tricky balancing questions is asked to do it.
Could I just come back to the purposes? To take one extreme case, one of the purposes permitted is where somebody has died and you can't find out about that. You want to obtain information about their next of kin or about other persons connected with it or the reasons for the death. Would you say that it was improper to use, it was the powers of this Act should not be used for that purpose?
We'd say that possibly you might want to look into check his pockets first, perhaps, and do other things to check that it was actually necessary to do it. But at the end of the day, it may be, if you've got no other means of identifying somebody, you might be able to justify the use. But I'd like to know...
Even though there's no crime?
If in connection with the fact that the person there whose data you would be looking at, if you were targeting the individual who had been deceased, and you're trying to identify somebody who's connected to him to notify them of his death, you could arguably say that that very narrow purpose could be justified. But again, if you were only opening the doorway to looking at the information connected with a deceased person, you'd have to be very careful in terms of the safeguards of how you look at the other information, because clearly we don't communicate only with ourselves. His communication data will be connected with third parties and other people. And if you're only simply using that gateway to identify somebody whose data, they may not object to their data being processed simply for that purpose. Again, it comes down to the degree to which you're using that trigger and the proportionality and the necessity. And have you looked at alternative mechanisms? Don't just jump up and down and say, can I use the internet to find out who you are? I mean, a simple check of the pockets, or has he got a business card that I can go and contact his employer? Might work better first time.
We appreciate the detail of your answers, but I think we'll need to encourage some brevity as well. Mr. Mosley?
A very simple question, I apologise, Lord Chairman, but I'm not a lawyer. Is there actually a definition of necessary and proportionate? Is it quantifiable or is it measurable at all?
Effectively, in human rights terms, what you're looking at is there a legitimate aim? So, in the context of Article 8, there may be other issues, but we're looking at what's the purpose for which you're proposing to do this. So, prevention of crime, etc. And you would look at the severity of the weight for saying that there was a purpose and there was a reason to do it. Then you would look at legitimate aim. Is there any alternative means of achieving this goal? And have you looked at the safeguards to make sure that there's no alternative risk? I'm sure Rachel might want to say something else about this as well, but there is a clear set of frameworks which look to show that somebody has actually conducted the balance between the goal at hand and the impact on the individual in order to look at whether or not they can achieve their purposes through other means. If they can't, that puts weight on justifying the interference. How serious is the interference at hand? I.e., are we looking at monitoring somebody's behaviour for months on end? Is it going to impact on his communications for a long time, etc.? So there are a number of different exercises you go through.
Can I stop you there? Have Justice got a little paper on proportionality?
We can help the committee
I think
with that.
We'll happily see a couple of page document on setting it out, if we may. Dr. Hubbard, and I think we're now open the floor to everybody to participate.
Thank you, Lord Chairman. And can I just declare an interest, again, as a member of the Advisory Council of the Open Rights Group and as a former member of the Liberties National Council. And I got to ask a question in the last session we had with the two of you, and there wasn't time for you to answer it. The transcript doesn't even include the yes that you said. One of the assumptions that's been made throughout this bill is that there is a clear distinction between communications data, the who, the where, the how, and so forth, and content. And one of the Home Office's principles is that these are clearly separable. Are you all confident that they are, in fact, completely separate and would always stay that way?
I think, for the record, the question I answered yes to was not that question. So, because my question to this, my answer to this would be no. So to do an opposite, no, I think, and you'll hear technical experts say this, but I think, to use the example of an offshore service provider, if I connect to that service, my ISP knows I have connected to a service, let's call it Yemeni Mail. And if they want to know who I have emailed within that service, which is the proposal of the bill, that is content of the communication between my computer and Yemeni Mail. So the idea that there is some simple distinction, and that's before you get into encryption, before you get into architecture, the idea there is a simple distinction, I think, is disingenuous and misleading.
Again, I don't think there is. I think the committee should think of the idea of separating communications and content data as is proposed, particularly in the black box element of this bill, as applying a sieve. If you imagine you have a sieve, everything has to go through the sieve, and then you have to catch some of the communications data in order to establish what that communications data is. So this is necessarily a little bit fuzzy. You're expecting and hoping that the algorithms and the computers that you're using are going to do this absolutely cleanly. And I think it's also often, sometimes a communications event may well imply or tell you essentially what the communications content is. For instance, a URL will tell you the whole of the content. And if a website is a single URL, it's a one-page website, then retaining the URL of that will tell you exactly what the content is. Other times it will tell you merely broadly what the content is. Perhaps, if I read the Sunday Telegraph every week, and that pretty much tells you the content that I'm reading. And similarly, if I read The Guardian every week, then that tells you something different. So it either implies about content, or sometimes it can be the content. And in any case, in terms of what the bill intends to do in terms of retaining communications events, you have to sieve everything in order to find the communication event details.
In addition to the points that James made there, I think there's also a conceptual issue here. To what extent does it still make sense to talk about communications data being separable from content because it's less revealing? And that's sort of the premise upon which these proposals are based. When we're talking about things like web addresses, how is that less revealing than something traditionally recognised to be content? That's incredibly revealing information.
And we just reiterate that. I mean, the traditional description of communications data is envelope data, can be misleading. Actually, in terms of modern electronic communications, there's an awful lot that can be found out in terms of disclosure of the simple information that surrounds a particular communications event, where you are, where the person that you were speaking to was, how long you were speaking to them for, how much data you might have sent them. You send people their photographs and various other things. And again, web addresses. Even the Information Commissioner expressed his concern that you can learn a lot about somebody from their web history, and it's something that you'd have to be wary about. But I would Justice would defer to others on the actual technology. And the problem is that with Clause 1 being quite so broad, we don't even have the government's explanation of how the technology will work. So we have to be slightly cautious in terms of our being able to assist you.
So do any of you have any faith in the assurances that are in the bill and the Home Office commentary that this will not allow for any access of content?
Well, of course, I assume the Home Office haven't read the bill with regards to postcards, because the last time I received the postcard, the content was written on the outside of it, and the bill expressly covers material and data written on the outside of items transmitted in the post, and that is content. And there are various other situations where the bill is drafted in a way where data relating to content could be caught. So I think the basic premise is there.
You used to think that what you wrote on a postcard was fair game.
I think I would agree with that, but I would also say that it is still the content of a message. And if we are trying to distinguish the content and the communications data in that example, the bill would apply to both.
I think a postcard being fair game for your relatives is a different thing from a postcard being fair game for the security services and for private companies to log on behalf of the government for future investigations.
I think that if I sent a postcard which had sensitive security information on it, I think I should be fully entitled to be found out.
If you wanted to just comment on whether you have faith in the assurances, you don't have to comment on every question.
I was just going to add a very brief point, which is that although we have problems trying to assess how much faith we could have, because we don't know what the technology is that's going to be used and we haven't had the government's explanations, even on the existing rules in REPA, look at the interception communications report, albeit that he only identifies a few mistakes. Mistakes there are, not least local authorities completely misunderstanding the type of data that they're allowed to ask for. Local authorities who are expressly barred on the face of the statute from seeking data for purposes other than the prevention and detection of crime, expressly authorising themselves to get that data until, just by chance, the interception of communications data may have audited it and said, actually, you've asked for it and it's ultra-vires and you should never have asked for it. But actually, mistakes happen.
Can I return briefly to the way that communications data works? Because it's split in the bill into traffic data, use data, and subscriber data. Subscriber data we've discussed as sort of being roughly equivalent to a telephone lookup. Actually, looking in the bill, it says it's information other than traffic data or use data held or obtained by a person providing a service about those to whom the service is provided that person. Would your reading of the bill therefore mean that if it was my Facebook account, that would include any posts I'd made, any pictures I'd put up, any likes I'd made? Would that count as information held about somebody to whom the service is provided? Or would that count as content?
I think it is subscriber details. Actually, a lot of this is subscriber details because your profile on a service is all the set fields that you have to fill in order to create or maintain an account. So on Facebook, that would certainly include your date of birth, marital status, your sex and your age and so on, but also, as you say, the likes that you had made, the particular interests that you'd identified, quite a considerable amount of information which would really be content except that it has been attached to your profile and is therefore, in the terms of the Act, subscriber details. So there's an obvious case to just slim that down to a number of set details that may be described as subscriber data.
I think that's very helpful. If I just ask one last question, then I'll move on and let somebody else ask questions, which is about the effect internationally of this. It would be interesting to get some sort of perspective to the extent, I know some of you have addressed this in your previous comments, particularly given, Joe Biden, the Vice President of the United States, said that where countries pursue monitoring arrangements, that could lead to businesses moving abroad to avoid those arrangements. Are there other countries which have techniques like this that use black boxes like a proposed, and do we think there would be harms locally to our industry for having that?
Our understanding is that the only countries which use this kind of DPI technology on a national level are in fact China, Iran and Kazakhstan, and I know this was the evidence given to the committee last week. We haven't undertaken detailed comparative research, but on the basis of what we've established so far, we understand that's the case. We also understand in a number of other countries, Egypt, Pakistan, Tunisia, DPI software is used at a local level for monitoring surveillance of the population. I think we have to be very concerned about our position here when other countries in Europe, as I said in my introduction, are challenging the constitutionality of current arrangements, and given that this government committed to ending retention of communications data, retention of data rather, unnecessarily. I think we have to think about the direction that these proposals are taking us in, and also bear in mind that the current arrangements are subject to challenger references being made to the European Court of Justice.
Which other countries across Europe are challenging them?
Our understanding is that Germany has found the provisions to be unconstitutional, the Czech Republic, Bulgaria, I'm afraid the other two escape my mind at the moment, others may. Romania
and Cyprus.
Cyprus also.
And Ireland are challenging the existing data retention directive in the European Court of Justice.
Yeah. Okay, thank you very much. Mr. Mosley.
I'm very interested in clauses 14 to 16, which establishes filter. It's been described as a filter by the Home Office people that we've spoken to. You could probably look at it the other way around. Other people might describe it as a search engine to go out there, pull all this data together and send the results out. What's your personal views on this? And do you think the filter protects or impinges on an individual's privacy?
I think to refer to the earlier points, actually, the filters highlight this change of, rather than having small amounts of data held that we pursue with a named individual or a named device, The filters are the way of bringing lots of data together to produce a result like a search engine would do, without necessarily requiring that data. So one technique currently used is geoboxing. You say, here is a box on a map, tell me every device from this data that's been within this area. And so I think the filters are intentionally, indeed they're the enabling part of the database function. Central database, lots of little databases is irrelevant. The output to the officer is the same. And that filtering provisions are so broadly worded and so poorly drafted that it could allow mining of all the data collected without any requirement for personal information, which is the very definition of a fishing trip. Mm-hmm. And then I think the metaphor someone else used is we'll be fishing in the sea with a net made of string and we'll catch some small fish, but the sharks will still carry on.
Absolutely agree with the points made there, and I'd just add that we're incredibly concerned about the role that these filtering arrangements provide for the state at the very centre of these proposals. These filtering arrangements will essentially join up the system of databases to create an integrated system. They will take the atomised pieces of communications data and form them into an incredibly revealing, incredibly full and detailed whole. In some circumstances this will be done in order to establish the validity of the request in the first place, so before you even establish that the request is a valid one, and that's a real concern for us.
So I think this area, this does create a very large number of potential risks, because you can remove people's privacy through several steps if you can take if you can match up data. So you can attach a number of different identities to one person, for instance their mobile phone, their normal phone, their work email, their personal email, their Facebook account, so on and so on. And then you can build up from that a map of all of their communications, both in time and to a certain degree in space as well, because you have the geolocation data. Because you can do that mapping not only against one person but other people, you can potentially identify people like whistleblowers, you can identify journalistic sources, perhaps people who are worried about their judicial, their legal position and trying to consult somebody for legal advice. So all of those sort of cases where somebody might be either technically or actually breaking the law, but nevertheless they're acting in the public interest, they're going to be extremely dissuaded from taking action, and that can have severe impacts not just for exposing potential corruption within government or the police or elsewhere, but also damage journalists' relations and their ability to report, and the client and client-lawyer relationships. So that's one set of potential risks that come from connecting this data up. I know that the Home Office is saying no, they're not going to use this data in this sort of way, but that's pure intention. The data will allow you to do this. So I can't imagine how they're going to be able to justify to themselves not using capabilities they've spent several billion pounds on. The other set of risks comes from the ability to hack, which partly comes from the fact that you've got a distributed database and there are multiple access points, and these access points are available across the internet. And you might think that I'm sort of sitting here saying, well, what do you mean hacking? This surely isn't going to happen. We're going to be able to keep this data very, very secure. But I think we outlined one example last week, a little bit about what happened with Vodafone in Greece in I think 2004, where the Greek cabinet and senior police officers and so on, their data got access through essentially a government backdoor which had been installed in the equipment that Vodafone had. It was hacked by persons unknown, and they got fined something like 70 million euros because of this data breach. The data breach occurred because governments had asked their equipment provider, Ericsson I think, to install backdoors which they might want to use in the future. The backdoors weren't enabled because Vodafone or the Greek government didn't pay for the backdoors to be enabled, but they were there. And so somebody used them, and we still don't know who. Suspicion lies with the US government, but that's not a given. Right. So the other example, which was I think in 2010, Google had been asked to provide government backdoors so that people could make surveillance requests similar to the sort of things that are being proposed here. And they were attacked by a number of people. A number of people were attacked, but they were attacked from China. And somebody from China, presumably the Chinese government, but I don't think anyone's got conclusive proof, gained access to that data and obtained some of the email records of Chinese citizens. Now, I think it is believed that that was done for political reasons. Again, this is a government-mandated backdoor installed, meant to be secure, accessed by people who have criminal or political intent from a foreign jurisdiction that you have very, very little control over. This is a real risk that has been created. And when we talk about where is the proportionality and necessity of collecting new data, we have to recognise that in collecting data and in creating access powers, we are creating genuine, real risks to every citizen if we're collecting data about every citizen. And that is why traditionally surveillance is targeted at individuals, and that becomes much more important in this sort of data-rich world.
You've highlighted backdoor.
Carry on.
You've highlighted some problems with backdoors. Surely the advantage of this bill, if you legislate for it, if you put this filter in place, within the filter you can have security, you can have audit, you can have logging, you can have all these things in the filter. There's no need for backdoors. Surely we should be trying to make sure that this bill legislates for it all, provides the frameworks, it can all be done legally above board without the need for backdoors. In that case, isn't that a good thing?
How does a filter work without accessing a number of databases and comparing that data? And without a single database, how do you do that without there being a number of databases, all of which have access?
Okay. There's one other area within clause 1416 which concerns me, which is it doesn't actually specify who will own or run or look after this filter. In fact, it gives explicit power for the Secretary of State to transfer it to the functions to other designated public authorities. Have you any thoughts on that?
I mean, we have concerns about that. There is the potential. There's the obvious uncertainty, which is a problem in and of itself. But there's the potential that this creates for filtering arrangements to be run by, for example, an organisation more on the front line even than the Home Office. So that has to be a real problem in terms of operational involvement and the ability to impartially operate a system, a service so central to the system. So that's one concern. In terms of sort of co-opting other authorities, the Information Commissioner, etc., into the system, they are effectively and should be a check on the system, and co-opting them into the system in that way would not, we feel, be appropriate.
I think far be it from us to cast aspersions on the Home Office's ability to manage things they've contracted out. But the broader issue...
with the local, wasn't it, rather than with the government?
Let's move on.
I think that the point is absolutely right, that where you allow these filters to sit is central to the way that the information will be accessed and how the filters can be used. And I return to my earlier point, is who is stopping these filters being used for unnamed searches, for situations where certain profile criteria may exist. And what the purpose of the filtering is to show me who meets these criteria, rather than show me what this individual or this device has done. And I think that is the role of the filters. And if that is anywhere near the front line, you have a serious risk of conflict of interest and of abuse.
Yeah, Mr. Killock, you said, without getting into conspiracy theories here, that it may have been the United States government which leaned on Google to build in backdoors to the Greek system. In view of the fact that Google and Facebook are giant American corporations, and they've got to keep the American government happy, and the British government is hoping that Google and Facebook are going to cooperate to give us, the British government, the information they want, how concerned are you that our friends in Homeland Security may lean on Google and Facebook to give them the information as well?
Well, I think certainly that's a considerable worry, and I think there's a lot of cooperation there. But I mean, we have to be a little bit careful here. This discussion is actually about police access. Other sorts of access are not especially in scope in this conversation. I'm not saying that they're not of interest to you. They should be of interest to you. But in terms of trying to understand quite what the dynamics are, I think we should be a little bit careful to say this is about police investigations, special branch, other parts of law enforcement, rather than the sort of surveillance and access that MI5 in this country would have. And they have a different regime, which I'm sure we would be delighted to discuss, but I think it's probably a little bit broader than the committee wants to take on at this point. I could... Yeah.
That's all right, then we'll move on. If we've time, we may come back to it. Baroness Cohen.
Well, I've got two questions, one of which I think you have answered, really. I think everybody's telling me that communications service providers are not going to be able to capture communications data reliably and store it safely. So, I'll just check that there's no dissent there. One of the objections always made by anybody to inquiries, or what they view as repressive sort of inquiries, is that criminals and terrorists bad guys can easily and cheaply avoid the production of communications data. Do you have evidence of this? I mean, is this a point that you guys would make, or am I putting words in your mouth?
Well, I think the Home Office accepts that they will still have a capability gap of 15%, even if this project is 100% successful. And I would ask any government department to produce a demonstration of an IT project that's been 100% successful. Mm-hmm. So I think the real nightmare situation isn't the data being lost in reference to the first part. The nightmare situation is someone watching it. Because if you are not interfering with the data, but you are watching who is communicating with who and when and where, that information is extremely commercially valuable in terms of espionage, but also in terms of simple stock market manipulation. So the nightmare situation is someone watching, not stealing.
With all due respects, I mean, if people were going to do that, don't they have that capability now to do it anyway?
You're not asking...
So isn't that a bit of a red herring? Because if somebody's going to do it illegally, they'll get on and do it.
Well, for example, to use an example of a commercial webmail provider. The commercial webmail provider has an incentive to keep this data secure because that's their business model. And they will say, if our security is breached, our product is less attractive. A CSP doesn't have that incentive. A commercial service provider does not have the incentive to keep data about your email use secure because they don't want to hold it in the first place. So if that security breach did happen, the CSP's first response is, well, we do not want to hold this data, and we are being forced to hold this data by a bill. So there is a serious question to ask about the motivation. The attacks referred to previously were aimed at Gmail, and Gmail largely resisted those attacks. Can the same be said of an organisation which does not have a commercial motive to protect that data? Indeed, it could be someone working within that organisation. So there's a risk there of that data, and that's a serious risk. So you have the risk of abuse of access, not just loss. And on the second point, I'll defer to colleagues.
Sorry, what was the second?
The other point I was asking about was, is the general statement that you might as well not do all of this because criminals and terrorists will get away from it anyhow?
So I think serious criminals and terrorists will... there's sort of two areas that I think we're thinking about here. One is, if you like, commercial services, which is the vast majority of internet communications. And then there is personal-to-personal type of communications, which might well avoid some of those sort of commercial services. And those, most of those sort of communications from one person to another person on the internet, done entirely securely, not using commercial providers. Most of that's done by business. Most of that is things like virtual private networks, where businesses want privacy and they don't want their information shared with third parties, so they avoid that. The amount of communications which is done by citizens in that sort of way, where there is no record kept by a company like Google or Facebook, I'm pretty sure is vanishingly small. It may get bigger, it may not, but I think that's something we need to hear from the technologists that you are talking to. But my sense of this is that most ordinary communications are conducted through large organisations because that's where the investment is. You know, Google invests lots of money in getting people to use Google, so does Facebook, and people like the services they provide, so they use them. Therefore, records are kept because they have them for business purposes, and therefore law enforcement can get access to them. So, the idea that we're getting a decline, I think this really needs to be spelt out by Charles Farr and colleagues at the Home Office. I would just point out that the Home Office's own paper says that there's going to be 1,000, as I mentioned in my opening statement last week, there is an assumed 1,000% increase in data going across networks. The Home Office accept that. So when they say to you there will be, we'll only have 65% of the data rather than 75% of the data, what they're saying to you is, in 10 years, we'll have 650% growth if we have nothing, but we want 750% growth. I think their statistics pretty much bear that out. So we need to know where this 100% growth they're not getting, what exactly that entails, and why it is that they might find it difficult to access that, given the huge commercial availability of communications networks.
Could I just briefly add this? In addition to the sort of very sophisticated potential methods that have been mooted here for evading or getting around potentially the proposals set out in the bill, there are also methods of very little sophistication which could potentially be used to get around these proposals. So, for example, use of a mobile phone with an anonymised SIM, a pay-as-you-go mobile phone with an anonymised SIM. So the possibilities for evasion range from sort of those of very little sophistication to very sophisticated encryption and anonymisation techniques, hijacking the unsecured networks of others, etc., etc. It's a wide range of problems.
I might add actually that one of the more well-known techniques for avoiding government sort of surveillance is Tor, and Tor is largely paid for by the American security apparatus, or has been largely because they want to enable Chinese dissidents to avoid surveillance from the government there. So it cuts both ways at all times.
Lord Strasbourg.
I've got some questions about safeguards to prevent misuse of data. I think we may have strayed into these areas already, so we might be able to get through these quite quickly. There are concerns about the potential misuse of communications data. Do you consider that the draft bill seeks to address these adequately? And do you have any evidence of any abuse under the current RIPA safeguards?
I'll start off because I think I'll be very brief, but I think the others can deal with the technical issues. I mean, our starting point, to repeat what I said earlier, isn't necessarily about abuse. It's about expansion of retention and collection, which, as we know, when you expand the amount of information you keep, it becomes more difficult to manage. So the likelihood that you're going to have mistakes, not misuse necessarily, or abuse, which is potential, but we don't say that that's necessarily the major problem. You just expand the potential for error. And so you have to look in great detail if you are going to expand, and we don't know how or why or what, and we're a bit concerned about what the actual expansion will involve. And we're very concerned that there's no justification being provided so far. But when you're looking at that expansion, you have to look at what the safeguards will be. And nobody's told us what they'll be. So actually, it's incredibly difficult for us as informed commentators to try and help the committee understand what the risks, not only of misuse, but of error. I mean, we have to simply look at the fact that these databases, as much as they'll be automated and otherwise running on various programs which themselves may be fallible, they'll be designed by human beings and run by human beings to a certain degree. And we all know that when it comes to data, people do make mistakes, often very costly ones, to those who have simply had their data stored, may never have known that it had been stored, but now may have the concern that it's either on the ether or sent elsewhere with no knowing who has it.
With respect, we've heard all that before, and if you could concentrate on the safeguards and whether you think they're adequate, that would help us.
I think the problem is we don't know what the safeguards will be, because we haven't been told what the technology is going to be, and we don't know how it's going to be stored, except for there's going to be some agreement between the government and CSPs. So, and the real question comes down to, we had the question raised earlier, oh, it's okay because it's not a government database. Really, it's private companies managing data that, as my colleague has said, they have no real commercial incentive to keep. So actually, the question is, do we trust the private sector to keep these databases secure? And if we do, what's the detail? Where's that trust? And what are the safeguards that are imposing on them obligations to ensure that there are protocols in place to avoid not just misuse, but to minimise error and mistake?
And do you have any evidence of misuse under RIPA?
I mean, as we said, under RIPA, you just have to look at the best evidence we've got is the interception of communications commissioners' reports, simply because those individuals.
Your best evidence is the lack of evidence.
Well, the lack of evidence, but also you look at the mistakes that were self-identified. There aren't many of them. There's maybe, I think the figure was 900 across law enforcement agencies that they identified.
Okay.
They're fallible.
If I could sorry, Jim.
Well, I've got one quite interesting piece of evidence, because most of obviously the public authorities don't report, and most of the time that's the evidence we get. But Google, one of the complaints has been made about the current access regime has been that Google don't comply with enough of these requests, and I think they've been turning down something like 30 or 40% of the requests made to them. Why have they been declining 30-40% of the requests? Because they've been inadequately framed. They haven't been signed off by officers. So, although not because they think that they're entirely inappropriate and they won't deal with them, they've just sent them back as poorly formed. So, if that's the case, Google have actually given us the only real example of how these requests are, statistically performing. We don't really have that as quantity from the Intercept Commissioner's report, because they just give numbers and don't tell us what the sample size is. So, but if Google are correct in saying they have to return 30 or 40% because they're badly formed, then I think we've got some evidence that this is not working very well.
If I could just very briefly say that in relation to the first part of this bill and data collection, in terms of safeguards, all we have really are empty assurances that all requirements of data needs to be kept securely without more. So that's a cause for concern, and that stops us from scrutinising potentially the safeguards envisaged by the government. But in terms of access arrangements and other parts of the bill, many of the safeguards proposed are process-related, formal requirements, for example, that the requisite individual be named in a notice, etc. So very little in the way of substantial safeguards there.
Okay, thank you.
Sorry, just add one point. The very definition of abuse is sketchy, because the problem is that if currently an officer views acquiring data as necessary and proportionate, it is by definition not abuse.
Yeah.
But as we heard the other day, there are police officers who think it is necessary and proportionate to use this data for road traffic offences. So is that an abuse? No, because the process was followed and the criteria is satisfied. Is that a fit use for a surveillance infrastructure not used in a democratic state anywhere else in the world? Well, I would say that is not a fair use, but by definition the officer said it's necessary, so it cannot be abuse in legal sense.
Right, thank you. Some of you have suggested that the powers in the draft bill might put off whistleblowers or endanger privileged communications, such as with lawyers. Do you think these are real risks despite the permitted purposes and the authorisation regime? And are there additional safeguards that could be introduced to lessen these risks?
Well, RIPA explicitly fails to recognise privileged communications. I think the Bar Council and the Law Society have both been very clear that there is no recognition for privileged communications at all in the existing regime. Indeed, there is no recognition for privileged communications with MPs. And I understand there is still, the Home Office is still to respond to concerns about the Wilson Doctrine with regard to this legislation, which is clearly raised, given that a constituent contacting a Member of Parliament would have their email recorded that they had contacted their Member of Parliament. So there's a clear issue there. I'd defer to colleagues on the further points.
Well, we are speculating, and we need to really understand and see precisely what the filtering arrangements in particular reveal. I would point to Ireland as an example of where this has occurred. The case that's being brought by Digital Rights Ireland, I believe, involves individuals whose data was abused. And there was a recent article in The Guardian, I'll send the details of that to the committee, where, again, there have been cases of journalists and police finding data incorrectly used. And inducing some degree of fear, a sort of culture of fear among some of those groups. So it's entirely possible, once the data is collected, for that sort of thing to arise. And so we have to firstly understand what the proposals really are. And the committee and us, I don't feel we have had those details explained. And then we have to start to understand how the data that's been collected might actually be interrogated. But we certainly see, I think, in other countries, some indications of how it can go wrong.
Thank you very much. I think probably your question might have been covered. Okay, Mr. Whittaker.
Thank you. At one end of the scale, we've got obviously the government, the police, the security services saying they have a need. And at the other end, we have you guys who are saying the bill's not fit for purpose. What would you suggest we do to make it fit for purpose?
Well, I think the answer there is that we just don't think the case has been made out for these type of proposals. I mean, when you're embarking on a human rights assessment of these proposals, you have to look at the revealing nature of the information, of course, and then you have to look at potential law enforcement gains. And the idea or the suggestion that these proposals will lead seamlessly to gains in law enforcement is something that we challenge. You know, we're told that in 95% of serious criminal investigations, communications data plays a role. What we're not told, however, is how many of those investigations lead to successful prosecutions, what kind of a role communications data played in those prosecutions. Was it central, was it peripheral? Were there other techniques that could have been used in order to get to the same point?
So, in your opinion then, nothing will make this fit for purpose?
In our opinion, the data retention arrangements that we already have in place are very hard to reconcile with the protection of personal privacy. The blanket retention of data about individuals, as opposed to targeted surveillance, with which we have no problem, should not be a feature of a liberal society.
So in your view then, absolutely nothing can change in this bill to make it fit for purpose?
In our view, the basic provisions set out in this bill take away reference to access and scrutiny, which basically replicate current provisions. The basic provisions of this bill are to require communication service providers to retain data that they would never keep for their commercial purposes, as essentially a sort of arm of the state for these purposes. And we do not think that can be justified.
So no then, there is nothing that can be done to make this bill fit for purpose.
Yes.
What about the other rest?
We shared concern that basically Clause 1, we just haven't seen the evidence. Not least, we don't quite know what the scope of Clause 1 is. So if the assumption is, reading it as drafted, it creates a very large power to, as Ms Robson said, collect pretty much any information that passes from anybody through a CSP, then that's a big ask. And actually, what you've got to do as a committee, and us as an objective observer, is look at, what does this get us? What does it gain? Actually, we've got quite a wide gateway provision in REPA already. Yeah. And what you're talking about is adjusting the ask to the evidence that it's needed. And actually, the problem we've got is we haven't actually seen the evidence from the Home Office, other officials and data users, why this vast expansion is justified.
So what would you do then? What would you suggest?
I'd drop, if you're asking me to rewrite the bill, I'd drop the first part, read our report on REPA, and don't expand the collection and retention of data. Just up the existing the existing safeguards in REPA to perhaps make it fit for purpose in the first place.
It's very clear and concise.
Thank you.
Okay. Anything else, Mr. Whittaker?
Just
Yeah.
I think the problem we have here is that we don't have a clearly defined problem to give an answer to. What we have is a sort of bald statistical statement that access to communications data is going to grow by 650% to 750, rather than 750%, or if you want to phrase it in the way the Home Office say, it's going to decline from 75 to 65% access.
So can I ask you yes or no? Is it, what would you do, if anything, to make it fit for purpose? If you don't think it's fit for purpose, could you make it fit for purpose, or do we just kick it out?
Given that we don't really know the problem, it's an incredibly hard question to answer. You know, so
but with all due respect, you have a lot to say on this bill. To say that you say there is very little information in it.
There's a lot of implications of what the schemes appear to entail. That's to say, filtering databases, connecting databases, extra powers to collect. But there is no indication really of what precisely is being targeted and why. And it seems to me that there's a feeling among, it seems to me there are two things going on. Firstly, that the Home Office believe that by connecting data up and being able to make queries against it, that they will gain some very nice and extremely intrusive but revealing and important for them powers, new powers that they don't really wish to discuss with the public by telling us that it's about maintaining capability. I think that's one reason why they're doing it. I think secondly, there is some possibility, given that they're saying there is this gap between what they might access and what they currently are going to access, there is some possibility that they are finding it difficult in some circumstances to get hold of communications data which exists. But when we ask what that communications data might be, we get told things like, we don't really want to discuss that because that'll help people hide themselves. Without that information, trying to fix this bill is very difficult. I think there is probably something in trying to develop better relations with overseas companies, understanding how it is that they get data, whether the legal regimes are sufficient, whether police officers understand how to get that data from overseas companies. There's a bunch of questions like that.
So in your view, then, it's not fixable?
No.
Thank you.
The bill is not fit for purpose, and that was the view that I took, and it was also the view that the current parties in government took in 2009 when Labour proposed the same thing.
So what would you do to fix it, or would you not fix it at all?
It requires the monitoring of every communication made by everybody in this country.
So would you fix it, or would you not fix it?
It's distinctly undemocratic, so I think it should be thrown out.
So you think it should be thrown out? Thank you.
Thank you very much. Now we must be brief if we can. We're running rather late. Mr. Ellis.
Just briefly, in fact, there was a difference between the Labour proposals of 2009, wasn't there, Mr. Pickles? Because actually that called for a central database, whereas this doesn't. So just correct that.
I would challenge that immediately. If you have a look at the 2009 consultation document issued by the Home Office, it states quite expressly the government rejects a central database, and the Information Commissioner welcomed that in their response to the 2009 consultation.
So as far as what the problem is, the mischief that this bill is attempting to redress, all of you tended to say that you don't see what the problem is, but isn't it obvious, and haven't you heard the accounts of others, which is that technology has moved on, communications data has moved on, the authorities are saying they can no longer monitor in the same way that they used to be able to when it was landlines and mobile telephones. There has been a degradation in their monitoring ability. They want to stop terrorists and criminals from committing offences. So that is actually obviously the case of what they're trying to achieve, isn't it?
That needs to be really spelt out exactly what that means. I mean, the sort of things that I've heard
around
Parliament.
Hold on, Mr. Killock. You've said that, but you also seem to want the authorities to tell you and your colleagues what it is that criminals do to avoid detection, so that anyone listening to this committee will hear how exactly who has bad faith in mind can use those tactics to avoid criminal detection.
Under current data retention, we know exactly who retains data and what. So we know precisely which ISPs are retaining logs and exactly what are in those logs. So when it comes to the inaccessibility of data, we need a bit more than assertions. And an assertion that goes around Parliament a lot is, well, what about Skype? Now that sounds quite an interesting one. Skype's peer-to-peer, so calls go from individual to individual. Presumably they don't produce data trails. But Skype is also an application owned by Microsoft. There are some centralised parts of their network, and there are backdoors built into it. So, what we need to know, I'm afraid, in order to understand what this apparent capabilities gap is, we are going to have to hear what type of communications are not being accessed and in what circumstances.
Because we're running out of time, Lord Chairman.
Yes, that is correct.
And
then we'll move on to Mr. Wright.
We started our research that we did, and I'll provide that to the committee, on the basis that we thought there were problems with REPA, and that part of it was that technology had moved on, and that's where we were in the 70s. We were saying, gosh, technology is racing ahead and the privacy law is not keeping up. Now, the question is, technology is racing ahead, but that also means that what you could be looking at is vastly greater powers to monitor individual activity by capturing data. For example, we use a very facetious example at the start. Envelope data, it does come from, let's track who sent what letter to who, or how the telephone exchange knows who is speaking to somebody else. That's very limited amounts of information. Who called who when, who wrote to who when, what are their social communications, how often do they speak, etc. But actually, technology has advanced in such a way, as we've explained, that we can tell where you were, how much information you sent to each other, how often you met, what your history on the internet was. So it's a changing pattern. I wouldn't like advancing technology to be used as it means that we're depreciating in the amount of data we can collect. It's simply that advancing technology is perhaps opening up avenues for surveillance. And the question for parliamentarians must be what avenues are appropriate, proportionate and necessary.
Okay, I'll stop you there. Mr. Wright, I need some time.
Turn briefly to the monetary costs and benefits of these proposals. You may have seen previous evidence that we've taken where Home Office officials have given us estimates of the net cost of the draft bill, and they are saying it will be £1.8 billion over the next 10 years. Do you think that's realistic? And secondly, what do you think about the net benefits figure that they've calculated of £4.4 billion? Again, do you think that's a realistic figure?
I might note, firstly, I formerly worked for an IT contractor at the time when the Public Administration Select Committee was producing its report into the rip-off culture in IT, and I would urge the committee to read that report if they're interested in how IT contracts are procured. The Minister couldn't even bring himself to say at the dispatch box that the £1.8 billion estimate was accurate, sir. Those of you who read the parliamentary question asked by the member for Leighton and Wanstead, apologise for Duncan Hames MP asking about that. The Minister couldn't say so. We've also asked the Home Office to provide details of the breakdown, so both the cost and the benefits and where the cost and benefits fall, and we've been told we can't have this because it affects commercial interests, security and law enforcement, which is surprising given that the majority of the benefit falls on HMRC. I can't quite see how tax returns are either commercially sensitive or indeed security and law enforcement. I would merely refer to the government's own IT strategy, which says there is a presumption against IT projects over £100 million because they don't work. I would refer to the fact that, is there a competitive market? No, because, as we've heard, suppliers don't know what they're supplying. Is government an informed buyer in this situation? Again, I would refer to previous IT projects. Will this software be non-proprietary, so available and integrated? Well, no, because, as we've previously heard, suppliers will only be told, in certain instances, what they're building. And finally, will it integrate with the existing legacy estate? Well, as the Public Administration Select Committee looked at, government has no interest in understanding this because it will cost too much. So I think, in answer to the £1.8 billion of costs, I will eat any hat if it costs £1.8 billion because it's simply not true, it won't happen, and the idea that this will come in on budget is simply remarkable. As for the benefits...
So your view is it will be a lot more than that?
I think it will be a lot more by a factor of 10 at a minimum.
Right. How much of that? How much risk will the private sector bear?
I think from past experience of government IT projects, very little. As from every IT contract ever produced, and indeed if you look at the National Audit Office report today into the Home Office's management of the border agency, weak leadership, poor project management remains a hallmark of public sector procurement, and I see no signs of that changing anytime soon. this would make history as the first government IT project to come in on budget.
So what you're saying
on
to the
time.
committee is you estimate 10 times the cost that government are quoting.
When the first proposal was floated in 2009, estimates were actually 18 billion.
Okay. Anybody else?
So don't know that I can say exactly what the costs will be, and we need to hear a lot more again from the Home Office. But we need those breakdowns to understand precisely what the proposal entails and where the potential cost overruns might be. But the fact that Charles Farr, who proposed the Intercept Modernisation Programme under Labour, sat here and told us that black boxes were not a particularly big concern for this bill, I think tells us that he has put his ambitions, and the Home Office have put their ambitions for large-scale data collection through black boxes on the back burner. Now, that may well be because money's a little bit tight right now, and it may well be, especially given the fact that the bill is an enabling act and allows new collection duties to be imposed over time, either directly on service providers or through these collection procedures and black boxes, either route. You could easily see new categories of information being included, new duties of retention being included, and the bill going up purely because there was here's another thing we want, here's another thing we want. And over time, you end up with a scheme which looks remarkably similar to Labour's original proposals, and the costs look remarkably similar, even though the promise originally was rather less ambitious. So I think it's promising a lot, basically, to say that this is going to stay.
The only thing I'd add to that is, which is very comprehensive, I would just add that as technology develops, I think there's a great deal of technological opinion to the effect that the costs of adapting infrastructure to deal with new technological developments will be great and will be sort of endless and constant, and that is a real concern.
What about the cost of the additional regulatory regime that was being proposed earlier? Because one of the things you were suggesting, I'm changing tack a little here, is that you wanted greater oversight, for example, through the judicial process. Have you got any estimates of any additional costs that would be placed on if we had further judicial oversight in terms of giving permission to search for data?
We haven't extrapolated that, but I mean, there is some data in connection with the extension of judicial oversight to local authority decisions under REPA. And I'm sure if you wanted to ask for that information, I'm sure the Home Office could compile it by extrapolating the costs that have been incurred by local authorities asking magistrates as opposed to going through the traditional administrative route.
That's helpful.
One really cheap part of the proposals that some of us have raised is the idea of notification. I mean, obviously, as you were hearing from the police and so on, there are going to be times when notification should not occur. Somebody who's been investigated shouldn't be notified because they are going to be under continuing investigation, or are suspected in a more, in that sort of sense. But simply telling people that they have been investigated and their data has been supplied isn't going to cost very much at all, and that could provide a lot of evidence about abuses, if particular populations are being profiled, if particular individuals are being somewhat hounded, or if the investigations were just simply inappropriate. So that might be a very cheap means of providing transparency, if you like. I'm certainly not advocating you don't do the judicial.
We need to move on, Mr. Killock. It's an area it's of interest we shall wish to explore, but not right today. Anything else, Mr. Wright?
Thanks, Jim.
Okay, thank you very much. I'm sorry we've overrun horribly, but thank you all very much. We could have gone on much longer interrogating all of you and getting the excellent information from you, which we will chew over. Please send us, those of you who we've demanded it from, the papers we've asked for. And thank you all very much for giving your evidence today. Thank you. And if I could ask you to move quite quickly so we can get the next evidence people in. Sorry being so rude, asking you to move quickly. But Yes. Welcome, gentlemen. Sorry keeping you waiting, but we've been in nearly all our evidence sessions. We seem to run a bit late. We find them fascinating and we interrogate at length. For the record, if you could state who you are and your position, Dr. Richards.
Okay, I'm Dr. Julian Richards. I'm the co-director of the Centre for Security and Intelligence Studies at the University of Buckingham.
Thank you very much.
And I'm Professor Anthony Glees, and I'm Director of the Centre for Security and Intelligence Studies at the University of Buckingham.
Excellent, thank you very much. Professor Strasbourg. Yes, Lord Strasbourg.
Well done. Thank you, Chair. Professor Glees, you stated on the Today programme in April that one of the arguments for the proposals in the draft bill is that it needs to be done because it can be done. Why does having the ability to access communications data necessarily mean that public authorities should be able to access it?
Well, in a radio interview, it's not easy to get an extended argument across. What I meant by that was this, that if there is unregulated space, and there is, and if this unregulated space is used for criminal purposes, and it is being so used, and if it is possible to mine such space to make it regulated and to apprehend criminals, then it should be done. It's a very straightforward issue. It's not sort of 50 shades of grey. It's a black and white issue for me.
What limits do you think need to be applied to state intrusion into people's private data? Are there in your mind no limits?
Well, I think that there are limits, but what those limits are is a rather deep philosophical question. I think the other way of looking at this is to look at the sort of regulations that exist. For example, the Acquisition and Disclosure of Communications Data Code of Practice in its 2007 version, which I've read with interest and care. That seems to me to be an excellent way of ensuring that the correct boundaries are kept. But as I say, there's a philosophical point here where you have people putting all sorts of intimate details about themselves quite freely onto the internet. What is private and what is public? It no longer means what it meant when I was a student 40 years ago, and I think one does have to have that debate. But as I say, in my view, the correct way to look at it is to ask yourselves what are the codes of conduct, the ways in which practice is regulated. And I think that in the documents that I have seen, that it is extremely well regulated, and that people should not be afraid of this. As I say, the end of the day, what this is about for me is the introduction of some kind of lawfulness into cyberspace. It's self-evident that something that's already being done should be done in areas where it can be done and needs to be done, and that there is this sort of public disquiet that this is called Snooper's Charter seems to me to be not an issue that has anything to do with the facts before people, but rather about a more general and indeed disturbing lack of trust in politicians, in the people charged with looking after our security, Director General of MI5, head of the Metropolitan Police, that these people aren't trusted when they say they need these things. I think that's very disturbing, but it's not a reflection on the things they say they need.
Do I take it then that you would have no problem with content being collected as well?
Well, as you know, this is not about what, it is about who, when, and where. Of course, content is a legitimate source of information, but again, as you know, people who want to intercept communications, that is to say, gain access to content, have to go a completely different route. And I think that's right. I think privacy is important. I'm aware of Article 8, and I'm aware of the other aspects of the European Convention on Human Rights, and I think that convention is extremely important. But in the real world of today, those people who rail against CCTVs, those people who feel that they should be allowed to conduct criminal activities on the internet, that somehow it's a free space and it's part of civil liberties and human rights, that they should be able to use that free space for all sorts of wicked things, from terrorism through to paedophilia, money laundering. I mean, you know all the categories as well as I do. That seems to me entirely unacceptable.
So you wouldn't be happy for content to be collected?
Well, content isn't addressed in this bill.
No, but
and yes, I am happy for content where it meets the very stringent different regulations that are required if content is to be looked at. Home Secretary's warrant. But it's always been like that. I mean, you know, we've had a secret service for more than 100 years in this country. It has always looked at these sorts of things. What has changed is everybody's desire that this activity be made lawful and be brought into the law, and I think that's very important. We need secret services. We give them a job of work to be done, yet they need to do it lawfully, and they need to be accountable for what they do. And as long as these things are all in place, I'm perfectly satisfied.
Dr. Halbert, thank you.
Thank you very much, Lord Chairman. Firstly, I'm struggling to understand some of what you're saying. Firstly, when you talk about this being a philosophical question about the limits of state intrusion, actually it's what this committee has to essentially determine and advise the government and parliament on. It's not just a sheer question of philosophy. And you've been talking quite a bit about regulation of the internet and making things lawful online. I hope you realise that this is also not about regulating the internet, which is a different issue, involved a whole range of other bills. And actually, it's that question about state intervention. You mentioned about people who describe this as Uper's Charter or who are concerned about CCTV. Can you explain to me how the argument that you made, either on the Today programme or just now to Lord Strasburger, wouldn't apply to a proposition, say, to put a CCTV camera in every single room to monitor what happens just in case it's useful? Because I think we would all agree that that would be quite useful in terms of reducing crime. I suspect around this committee and most of Parliament, most of us would agree that it wasn't the right thing to do. How does your argument differ from that?
Well, I mean, I think I'm a professor of politics as well as somebody with a special interest in intelligence-led activity. I'm sorry if I've confused you. That's not been my intention. As I say, I think the philosophy about what is private and public is a very difficult area. And in Parliament, I don't have to talk about things that particular MPs may or may not have done on the internet to publicise their activities. I mean, when I came into this meeting on the train from Bicester North, I suddenly heard the voice of Boris Johnson booming at me, telling me to be... So,
many of us have issues about that, but it doesn't quite address the question.
Well, I'll come to it. I just want to give you the context that the philosophical aspects of privacy are very important. Am I suggesting that there should be a Big Brother CCTV in every room? Of course not. And in my view, the people that make this claim are living in cloud cuckoo land. And if I may, I'll just give you some statistics. In 2003, I wrote a book about the East German intelligence service, commonly known as the Stasi. And if you have a look at a real surveillance society, which is what communist East Germany was. In 1989, the last year of the Stasi's existence, there was one Stasi member to every 7 East German citizens. In Britain today, there's one MI5 officer to every 7,000 citizens.
Professor Glees, clearly your book should be on all of our summer reading lists, but I still haven't understood your principled argument as to why you're saying that there is wrongdoing happening online. We could collect information about it, hence we ought to, which is, I understand this is the argument you're making. But the same thing doesn't apply, that there is wrongdoing happening in rooms. We could collect CCTV information on it. Why do the two not?
Well, I mean, the quick answer. Sorry, I didn't realise. The quick answer has to do with proportionality.
Right.
But something does not become acceptable if it's done in private. A criminal act is a criminal act, whether it's done in somebody's sitting room or whether it's done in front of Parliament here.
So whereas you were arguing that it should be done because it can be done and could be, so you now say that in fact it's about the proportionality. Your argument isn't about... Apologies. Your argument isn't about whether it is possible to collect this information online or from postcards or anything else, but whether it's proportional or not. Is that your new position?
Well, I'll repeat myself. You're being interviewed by John Humphreys, whoever it was, at 8:10 in the morning. You don't have time to develop a sophisticated argument. But what I tried to set up was the point that there is this space, there are these things going on this space, they're criminal things. It is now possible to at least have a go at finding out more about the things that are going on in this space. And if it is possible, as it is, and if bad things are happening in this space as they are, then it should be done. But of course it's a question of proportionality. If you're saying, do I think that councils should spy on people who put out the wrong bin? No, of course not. That's an absurd argument, and it is the consistent attitude of what I would call the civil liberties lobby to reduce this argument to the absurd that I think shows why this is not a matter of 50 shades of grey. This is something that is being done with existing communications. I'm told that every day, on average, each person in the United Kingdom sends 4 text messages. 30 million people...
On criminal matters?
I don't think it's on criminal matters, but I'm just trying to make the point that this is a new form of communication that is being used. 30 million people communicate with each other every day on the internet.
And you would collect all of it from everybody because somewhere out there are some people doing bad criminal things.
Not only would I not do it, but it would be impossible to do it. That is the point.
Okay, Lord Armstrong.
I think that many of us would agree that it was acceptable to have public authorities to access communication data in the interests of pursuing terrorism or counter-terrorism and serious crime. But the list of purposes is, it's not 50 shades of grey, but it's 11 or 12 shades of grey. Do you think that it's right that all of these purposes should be permitted for these purposes, for this act, by this act? I know it's taken over from REPA, so it already exists, but the government appears to have shown some signs of wondering about that, because they have reduced, in the bill, they have reduced the number of agencies that can collect on the face of the bill, give themselves power to extend it to other authorities so that people have to make a case. But there's also the question of the purposes, and whether some of the purposes, including some non-serious crime, would it be justified to use these powers in, or proportionate for the pursuit of bicycle theft, which is a crime. And for other purposes here, they're not criminal at all. Are you content with the list of purposes as it exists, or would you like to change that?
Well, Lord Armstrong, what I would say to that is what you have already said, that these powers were in REPA in 2000. And yes, by all means, one should always have a debate about what should be looked at and what shouldn't be looked at. I would say from my vantage point, on the one hand you have people like Sir Tim Berners-Lee, the father, as we all know, the World Wide Web, an advisor to the government, who in April this year said allowing this sort of data mining would, and I quote, lead to the destruction of human rights, unquote. And then you have people like me who say, well, a human right is also to be secure. A human right is also to be able to walk down your road without fear of being mugged, to go into a park, your children go into a park without being accosted by drug dealers. 40 years ago, there may have been a copper in every street corner and in every public park. That's not the way it is these days. And if CCTV, for example, can prevent crime and criminal activity, then yes, I am absolutely for it. Now, the question of proportionality, yes, I understand that. But again, I'd point this committee to things, for example, that David Davis MP has said.
I think, Professor Innocent, Lord Armstrong was asking, of the permitted purposes, would you concentrate just on serious organised crime, terrorism and protecting the economic welfare of the state, and would you dump the other items on safeguarding public health and allowing people to be dead bodies to be found?
Well, I'm happy with that, but if you...
So happy to dump the others?
I'm happy with it, but obviously the most important things are the things that come first, the things that involve serious organised crime, terrorism, paedophilia, matters like this.
Okay, that's it. And Dr. Richards for Lord Armstrong's question.
Yes, I actually do have concerns that the range of purposes for which these powers might be used are too great, and I would personally restrict it to serious organised crime and including terrorism, and possibly at certain emergency situations where lives are threatened, such as kidnaps and so on. I personally feel that the complete list of, I think it's there's a provision for collecting taxes and so on, goes too far in my book, because these are very intrusive capabilities, and I'm aware of privacy concerns. So I think proportionality for me means that only the most serious of crimes are legitimate purposes for doing this.
Lord Armstrong?
No, thank you, that's fine.
Okay. Sorry, Baroness Cohen.
Either Dr. Richards or Professor Glees or both of you, under current legislation, a large number of public authorities have access to communications data, likely to be replicated using order-making powers. Are you concerned by the length of the list of organisations? Should the powers be limited entirely to the police and security, or that there's a fairly long list of other organisations? But if you think that, if you, Dr. Richards, think that the sort of things you can ask are limited, do you think the sort of organisations that can ask them should also be limited?
The short answer for me is yes. I think the list is too long. I think the capability is absolutely necessary, in my view, for preventing serious crime and including terrorism and so on. But I do think there is a red line that this list perhaps crosses, in my view.
So would you limit the list to police and security / intelligence services?
I think I probably would, yes.
Well, if I could just say that I don't agree with my good friend and colleague, because I think that victims of crime have a right to be safeguarded as much as is possible. It's very easy to say, oh, fly tipping, for example, is not a major thing. But if you live in a beautiful place, as my wife and I do, and it's defiled by people dropping their rubbish there with impunity, why should that be allowed? I'm a zero-tolerance person, and I think the argument that there's some things that are perfectly all right. You can beat your wife at home with all the doors locked so nobody can hear the screaming, but you can't do the same in the street. That's anathematic to me, and I don't think lawmakers should be in the business of saying, come back to David Davis, saying that the people who are going to be caught with this new legislation are stupid criminals. Criminals are criminals, so they're stupid or bright is of no concern to me.
I share your views about fly tipping, but is it appropriate for fly tipping to use these powers to have access to communications data? I think that is the question that is in my mind. I'd love to stop fly tipping.
The question I was going to ask, but Lord Armstrong phrased it much better. We all want to take action against fly tippers, but would you use the powers in this bill to do so?
Well, I think you have to use the powers that you have before people send
yes, but we're here to decide whether we should have these powers.
Right.
Or not.
Yes. Unlike my good friend and colleague, Dr. Richards, I am comfortable with them. But obviously, as always in life, you have to prioritise. There's a limited amount of people to do this. There's a limited amount of funds, and they should go to dealing with the most important issues first. There's no question in my mind about that.
It hasn't seemed to have stopped some of the organisations and the 552 access requests from finding a priority to do some of it. Mr Mosley.
On those 552 organisations, there are only 4 listed on the face of the bill. Do you think there should be more listed on the face of the bill, or do you think they should just come along afterwards through delegated legislation or something?
Well, I think, bearing in mind that the public debate that has taken place, and bearing in mind that this is about the well-being of the public, I think the more that is set down and the more that is listed, the better. There should, in a mature democracy, it is absolutely right to be having this sort of debate, and if, again, I pay my taxes to the best of my knowledge, and I claim my expenses properly. If the use of communications data, which is currently not kept, would enable more people to stick by the law, well, I'm in favour of it. You know, this is the 21st century.
Okay, I think, yes, we're finished, Baron. Mr Ellis.
Thank you, Lord Chairman. So, gentlemen, can we come on to the issue of preventing inappropriate use of communications data? That's assuming, Professor, that you accept that there is a possible inappropriate use of such data. But would you accept from me that there's always a risk of misuse of power? We give constables the power to arrest people. There's always the possibility that that power will be abused. But here there is a risk of misuse. Would you say that it's proportionate to take certain risks in order to prevent crime and detect offenders? And would you say, therefore, that the terms of this bill are proportionate? And when coming to the issue of preventing the abuse, how would you propose to ensure that inappropriate use of communications is actually prevented? Professor?
Do you want me to go? Right. If I could deal with the second bit first, but I will come to the first bit. I think the right way to prevent abuse is, first of all, to have proper regulation and proper code of practice. And I said I've read the Acquisition and Disclosure of Communications Data Code of Practice. I think it's a very good document, and I'm very happy with it. But there is another side, particularly where we're dealing with the secret world and intelligence, and that is oversight and parliamentary oversight. And I am extremely concerned at what I regard as the failure of the Intelligence and Security Committee to play any role in this debate, or indeed any role in any serious role in any of the issues that have affected secret intelligence-led activity in Britain over the past few years. Our first port of call, by our I mean the public, our first port of call should be to the Intelligence and Security Committee to find out whether the Intelligence and Security Committee and its chairperson, its chairman, chairwoman, are content with the appropriateness of proposed legislation. And we are in a position, as I say, where we don't hear anything about that, and that's why sort of people like myself have to say the things that we do. So,
I think, Professor Glees, if I can elucidate slightly, I think you will hear probably by the 30th of November from the Intelligence and Security Committee, who will be conducting a parallel investigation to ours relating to the use of communications data for the security service.
Right. Well, forgive me if I say I think perhaps it's come 10 years too late, but I better late than never. And I mean, I know that it is proposed that the Intelligence and Security Committee be reformed. It is high time that it were reformed, and high time that it has proper investigation. But to go to your first point, the risk of people misusing the data. Of course there is a risk, and of course, we saw it in the papers on Saturday, people can suffer because of wrong behaviour, unlawful behaviour.
You're referring to people who are wrongly arrested because of communications data errors?
Yes, yeah, and that's wrong. And nobody in my position would seek for one moment to justify it.
Yes.
But just as the police will investigate people who are then found to be perfectly innocent, that's not an argument for saying police should only investigate people who they know are guilty. So too, when it comes to communications data, we should not let the abuse, in a very small number of cases, we should not let the abuse of this indicate that this is not a worthwhile activity.
Just briefly, Dr. Richards.
I think there are two things here, and it's very important. One is the question of the capability that you have in place to extract the data. And the second is the question of the process that you have in place for using that data. And I think sometimes in a lot of the debates around this subject, the second aspect is forgotten or missed by some of the critics. And I think there are some very rigorous procedures in place for accessing and using this data in a properly authorised way. And I think already there are procedures in place under REPA which ensure, in my view, that this is, although there are always risks of misuse of this data, using it inappropriately, I think those risks are greatly minimised.
So you take the risk in order to resolve the mischief that the bill is seeking to
I think if you have in place a rigorous and appropriate process,
so
then
just
yes.
finally from me on that point, do you think the penalties that are available are appropriate for those who would or could fail to comply with the requirements of the bill? So, for example, the offences that might include the Computer Misuse Act, misconduct in a public office, the Data Protection Act, do you think those penalties are appropriate?
Yes, I do, and I don't particularly see any need to change them. I think those things are in place for good purpose, and if they're followed appropriately, then...
Do you agree, Professor Glees?
Yes, I agree.
Thank you, Lord Chairman.
Thank you very much. Mr. Brown.
Can I just follow that up? I mean, you're both academics. We made a study of this area. And one of the great constraints on people taking part in wrongdoing is that they'll be caught and punished. Are you able to say anything to us about people who take information from the police computer and sell it for commercial gain? Public servants that look up people's social security records or medical records and sell it for gain. Do you know how frequently this is done and how often it is prosecuted?
No, not something I've done.
I don't. But again, I return to what I said just now. That there will always be risks that this can happen in a system. But I think you have to put in place procedures and processes, firstly to minimise the risk of it happening in the first place, and secondly to make it to monitor what's going on and to have the appropriate penalties afterwards if that does happen. I have some personal experience of working in a intelligence situation where we used to make these sorts of requests for these sorts of data previous to my academic experience.
Would you accept that a principal fear in the minds of our constituents is that information about them will be improperly accessed, improperly used, and maybe improperly sold to somebody else? What are the biggest safeguard against that is that somebody who does such a thing will be caught and punished.
I do accept that people will have those concerns, and I understand those concerns. But again, I think all you can do is try and reassure people that the appropriate procedures are in place to minimise that risk greatly, and that people are held to account afterwards if it goes wrong.
And you both believe that they are?
Well, I believe so, yes.
I mean, you're talking about very serious offences, and they are already serious offences. And I would simply make the point to your constituents that their interests are better safeguarded in regulating this part of the cyber domain as far as possible. By regulating, I mean allowing it to be examined for the purposes of fighting crime. They are better served than by letting it be a kind of wild west where there is no lawfulness. People are far more likely to steal data off you. They're far more likely to send you fraudulent emails if they think that they won't be traced. If they will be traced, they won't do it.
Well, I certainly agree on that point. To make the law effective, you have to capture people who break it and bring them to justice.
Lord Strasbourg.
We're talking here about safeguards against misuse, and you both seem to be perfectly content with the safeguards that exist in RIPA. We've heard in this committee of one known case of a prosecution over several years where there's been 500,000 applications for data a year. So let's say out of 5 million applications for data, there's been one case of misuse identified. There's only two possible explanations in my mind, although you might be able to come up with another one. Either the safeguards are as immaculate and watertight as you seem to believe, or the abuses are not being detected. Which do you think it is?
Well, for me, this comes back to, as it were, the first point, which is trusting the people we charge to look after this area.
Excuse me, but aren't the safeguards there to check whether we're right to trust them?
Well, I mean, you know, the statistic you've quoted, and I've not done research into it, but the statistic you've quoted could be taken both ways. It could be taken to mean that there is a very small risk, or it could be taken to mean there is a massive cover-up and the public don't understand. I'm inclined to believe the people, head of the Met, Director General of MI5, head of soccer, I'm inclined to believe that the people who do this with the right intentions. And in my experience, if I may say so, my work, if there's been a problem about intelligence-led activity in the United Kingdom, it's not been that it has been too interventionist, it's been that it hasn't been sufficiently interventionist. So things have not been found that should have been found. And if you accept that, and you accept that in a lawful, mature democracy such as ours, you have to place trust in the people charged with directing these matters, then I would say that statistic that you quoted to me bespeaks good news, not bad news.
I'm very happy to trust these people, but I'm going to check to make sure that I'm right to trust them.
Of course, there should be accountability. This is oversight.
Well, Mr. Wright.
On that very point, clearly within the bill, it's not the head of the Met that's making a decision about what data's gathered. It's actually much further down the chain than that. Do you think there is a need for more judicial oversight within the process? We've heard evidence already that requests for data inquiries really ought to be signed off at least by a magistrate. Do you agree with that?
Can I answer that? No, I don't, actually, for two reasons. Firstly, if the process is followed correctly, then even though the authorisation is given within the public body itself, it should all be logged and recorded, and those logs should be available to the Interception of Communications Commissioner for auditing afterwards. So there shouldn't be a situation where requests are being made of the system which...
Well, Mr. Richards, let me just break in there, because, you know, what happens if you get an organisation with a sort of canteen culture where somebody goes along to one of their friends down the corridor and says, I need some data on this particular individual or about this particular device. But I'll tell you what, don't put it down under that level of request. Stick it down under this box here, so that it doesn't show up on any monitoring report, so there's no data. It comes back to this point about people abusing the system. It's far more difficult to do that, isn't it, if you've got to present evidence before a magistrate?
Well, my experience is that firstly, that sort of culture just doesn't exist in these bodies.
What, nowhere?
Well, I don't think...
It didn't exist in any organisation in the
Well, I don't think it does. And secondly, if you've designed the system correctly, every request if you make of an IT system is logged. Records are kept of what data you've pulled, when you pulled it, why you pulled it, if it's designed correctly. So I do believe that you can design a system that can appropriately audit and monitor these things if you design it correctly. And the second point I wanted to make was that there's an operational imperative here that we heard the sorts of numbers of requests that are needing to be made to pull this data every year to support intelligence operations.
Well, hang on, it's not the scale of for intelligence organisations is a separate point. We're not talking about the number of requests we've got. There's a lot of dispute about what those requests are for. I mean, one would imagine if there was some element of oversight from a magistrate, it would actually reduce the number of trivial requests for data, if I can use that phrase advisedly.
But even so, it probably would. But I still think the scale of requests that the police and the intelligence agencies would be needing to make every day would be such that for there to be judicial sign-off on every single request, the whole thing would grind to a halt operationally.
That's helpful.
Very briefly.
Can I just ask it the opposite way around? Do you think that the magistracy is a sufficient safeguard and a necessary one just for the local government requests?
Yes, although as I said earlier, I'm not entirely comfortable that local government should be using this data anyway.
So what we're saying is that a local authority has to go to a magistrate, but that other organisations don't.
I guess we are saying that. Yes, I would. Yeah.
And you support that?
Well, as I say, this doesn't mean, the implication from your question is that then you have a willy-nilly, unregulated, unmonitored regime. That's certainly not the case. Procedures are in place to log and monitor. If the Interception of Communication Commissioner's Office are doing their job correctly, they have access to these details of every single request that's made and have the right to audit that at all times. So there shouldn't be provision for willy-nilly searching of data. Just because
there's the capacity in that organisation to deal with that?
Well, there needs to be. There should be. It should be built into the system.
Needs and should be is a different thing.
Well,
is it
I would take that as a necessity for this regime to be properly administered.
So is it able to do that now? Do you believe, on the basis of what's in this proposed bill, would it have the capacity to deal with that now?
Yes, it does.
I think it probably does.
It does.
Yeah.
Thank you very much. I'll ask Mr. Mosley now too.
Clause 1 of the bill gives the Home Secretary power to specify what data is held, who holds it and what equipment they use, but it doesn't actually give any more details how they will do it or what they'll actually ask for. Do you think it should be more specific in there?
Well, in dealing with that question, it allows me to add my ha'porth to the answer that Dr. Richards has given to the previous question, which is that I do think that we need more oversight. There's no doubt in my mind about that. And if members of the Intelligence and Security Committee should in future consist also of senior lawyers, I would be delighted. Senior academics too, as far as I'm concerned. I think the way this committee is organised at the moment, that it lies in the hands of the Prime Minister to decide who should be member of it, any Prime Minister, I think that's wrong. Now, we all know that the police computer is from time to time abused by police officers. We know that. And it's got nothing to do with this new legislation. That's the way it is at the moment.
Sorry,
and that is
sorry to interrupt
wrong,
you there.
But
can I just clarify something?
Yes, sure.
You said you need more oversight, and then you talk about the Intelligence and Security Committee, which I think less than 2% of the requests, of the 500,000 requests, relate to the security service. So we're looking at 98% of these requests relating to ACPO and the police.
Yes.
And you think there should be more oversight there, which would be the responsibility of the other committee?
I think that as far as the acquisition and disclosure of communications data is concerned, yes, there should be more oversight. I think generally there should be more oversight over data mining and formal interception. And who does it? As I say, we all know there's reform in the air. We don't quite know who's going to do it. But that is part and parcel, as is accountability, is part and parcel. But at the end of the day, I think we have to trust the people we charge with doing this, and there have to be very severe penalties for where that trust is abused. Now, it's my understanding, I haven't done a study of this, but it's my understanding that where police officers misuse the police computer, they are subject to very serious penalties.
Okay. But from that, in terms of this bill, you think it should have a bit more detail, yes or no?
Yes, but more detail,
okay.
absolutely.
Dr. Richards,
absolutely.
One of the concerns we've heard about is in terms of black boxes. Is there any evidence to suggest that black boxes would be needed, and do you have any concerns about introducing these into the mix?
Well, I think there are two elements to this issue. One is a technical element, and I'll confess straight away that I'm not a technical expert on telecoms networks, and the other is a risk and security issue. I think on the technical issue, my limited understanding is that because the telecoms network is becoming so dynamic and diverse and complicated, that the way this data could have been collected before, where you had particular pipes that everything went down and you could put a tap onto them, is no longer as technically feasible. Stuff's flying around all over the network in a very dynamic way. So I believe there are technical reasons why a more dispersed system of collecting this data is necessary. But as I say, I'm not a technical expert, and you'd need to speak to other people about that. In terms of risk, yes, clearly, any situation where you push sensitive equipment, and this is obviously sensitive equipment handling sensitive data, where you disperse that greatly out of secure locations and into the telecoms network, yes, clearly the risk goes up that something will be compromised or something will be hacked into, or privacy will be, there will be privacy issues. But we have to weigh the balance of the technical need to do this in a particular way and the need to protect it as far as possible.
Okay. One of the other new innovations within this bill is the filter. What's your views on the creation of a filter? Effectively, to me, it sounds like a search engine that effectively will mine all of the data that's out there, almost make it into one virtual database. Is that your opinion, and do you see any risks with that?
To the front end, obviously, there's the analyst who's pulling the data. Yes, in a way, it will look and feel the same. By using this filter mechanism, it'll look and feel the same as if there was a great big database behind the scenes that you could dip into to pull the particular information that you want. However, for operational reasons, it doesn't seem to make any sense to these intelligence questions that are being asked of the system about people's communication behaviours and patterns are quite complicated questions that require several different pieces of information to be pulled together and analysed in a fused way. So it doesn't seem to make sense to make that as difficult as possible by saying you have to get this bit from over here, then you have to get this bit from over there, then you have to get that bit from over there. That just reduces our intelligence capability to the benefit of terrorists and criminals that we're going after. So I don't particularly see. I think it's a sort of a null issue in a way. I mean, how you query that data. If you're collecting the data, then how you query it to a certain degree, to me, doesn't pose any more risks than anything else.
I can see some advantages about using a single filter to do these searches, because, as you said, it provides one place for security, for auditing purposes, for logging purposes. Would you think that if that would be an advantage?
Operationally, it'd be a massive advantage. Yeah, that's what you need to do at the end of the day. You need to combine lots of different pieces of data together to give you an intelligence picture of what you're looking at.
Okay, so it might be an advantage to channel all of the inquiries through the filter, because I think looking at the bill, it's saying that they'll do the inquiries normally, but only more complicated ones put through the filter. Do you think there'd be an advantage having only one access point effectively, which would be the filter?
There probably would be for all of the operational reasons that we've discussed.
Okay, and then lastly, the bill gives the power to the Secretary of State to transfer the ownership and the maintenance and the running of this filter to a third party. What are your thoughts on that?
Well, again, it may be a technical question. Again, I'll refer back to some of the comments I made earlier, that as long as you have the appropriate authorisation process and monitoring regime to ensure that everything is being done in a legally compliant way, that you can monitor and audit logs to make sure that people are using the system appropriately, then I don't necessarily see a problem with that, because it may be that the Secretary of State's office isn't the best place technically or logistically to be able to run this system anyway. So as long as you have the sufficient safeguards in place, I don't necessarily see that this is a problem.
Dr. Richards, the Home Office have called it a filter, giving the impression it's narrowing down the information sought. I think Mr. Mosley's called it a search engine, giving the opposite impression. Whose description is the more accurate in your view, a filter or a search engine?
My understanding of is that filter is a slightly inaccurate word for this, because you're filtering lots of different pieces of information out of the system and putting them together.
So Mr. Mosley is right, it's a search engine, more of a search engine in your
That's
view.
my understanding of it, yes. That's actually a more accurate
And you agree as well, Dr.
I do, yes. I'm not technical at all. But it is my understanding that a filter does exactly as Mr. Mosley says. Yeah.
Dr. Hubbard.
Thank you very much. You've both looked at approaches to communications data collection in other countries. And there's a variety of different approaches. Are there any around the world which use the approach that's proposed within this bill?
Well, my understanding is that the Australian government is closest to the United Kingdom in terms of this particular bill. The country that I know most about, apart from the United Kingdom, is the Federal Republic of Germany. And there the German Chancellor is on record as having said, in her view, Germany needs similar legislation.
But as I understand it, Germany currently doesn't have any aspect of the Data Retention Directive, so they are somewhere behind and trying to catch up to where we were years ago.
And for historical reasons, not just because of the Nazi past, but also because of the Stasi past, this is a very much more difficult issue in the Federal Republic than it is in the United Kingdom, where we look back on with pride on our long history of democracy.
Indeed we do. And so Germany is way behind and would like to catch up to where we are now. You say Australia is sort of roughly where we are, trying to move a bit forward. Are there any countries around the world which currently collect communications data or try to collect communications data in the way envisaged in this bill?
To the best of my knowledge, there's... I suppose the moment I'm going to say this, someone's going to disprove me, but there is no proper research in this. The distinction that would be made would be between the 27 member states of the European Union and the states of the European Economic Area, who share a common understanding of this problem, and then countries outside there. Obviously, in a place like North Korea, you would expect they would take a very different attitude. And that's why I come back to saying this is about lawfulness in a mature liberal democracy.
I suspect North Korea would say similar things about lawfulness. Are you concerned, do you agree, for example, with Joe Biden, the Vice President of the United States, when he argued that where you have monitoring arrangements like this, which impose some technological drag through back compatibility and various other areas, that might lead to businesses moving elsewhere in order to avoid them? And as long as there is a difference in different countries of what you have to do, there's an incentive not to be covered. Do you think there's a risk that companies may choose not to be in the UK or to do less activity in the UK or to store data overseas or something like that? Mr. Richards, Dr. Richards, sorry.
I personally don't think there is a big risk there for two reasons. One is that the telecoms network is a global network. It's very dynamic. It's very transnational, not just technically, but in terms of its management as well. So whether you locate in one country or another kind of becomes less significant technically. And also there are other reasons why, as a telecoms company, you might want to locate in the UK. And the question is, I think this particular fears about this particular interception capability, particularly given that it's supposed to be Europe-wide, and I know that lots of other EU countries are way behind in.
Sorry, Dr. Richards, this legislation isn't EU, right? The Data Retention Directive.
The directive that underpins it is theoretically will eventually appear in other parts of Europe if countries implement it appropriately. So I don't know. I think that any fears that telecoms companies might have over this having impact on their business would be mitigated by the other economic reasons for whether or not you would want to locate in the UK.
So just so I understand, you're saying the system is incredibly dynamic, and so telecoms companies could easily move. but they won't choose to do so because does it not weaken our benefits? You know, and if you're saying there are economic benefits to being here, do not at least weaken them?
What I'm saying is I don't think you do sufficiently, because there are other reasons why you would locate in one or other country that greatly outweigh any.
So you weaken them, but not enough. Okay, I think I understand that.
Say very quickly, I think there's an ethical dimension here that shouldn't be forgotten. That Mr. Biden may make these comments as an American does not impress me. I mean, we've seen a big company like Amazon, for example, managing to avoid paying tax anywhere in the world, as far as one can tell. This, again, is a consequence of the unregulation, the lack of regulation of cyber, the cyber domain. And I would argue strongly, looking maybe at the banking crisis and various other things going on, that the idea that unregulated space leads to economic success is extremely dangerous.
But again, Professor Glees, we're not talking about regulation, we're talking about data collection,
which is
very much not the same as regulation.
Regulation, to me, regulation means the imposition of legal norms and laws. That leads to regulation. And the law, to let people...
Professor Glees, the laws still apply. The question is about how you collect the information, which is not the same as regulation. A room which doesn't have a CCTV camera and is still subject to the same laws as one which does, it's still regulated in the same way. It's a question of what tools you have to collect the information.
It's a good philosophical argument. But as I say, the American pressure, which is that somehow of all forms of communication, the internet should not be subject to lawfulness, I would say, is not something that should be seen as being of great economic advantage, except to the particular companies that are able to exploit it. And we've seen where that ends.
We will hear what a number of the companies have to say about this later. Do you think that there is a risk about when you collect data into any sort of database, whether it's a central one or a number of other ones, that you create a honeypot, that there is an incentive now for people to try to attack that data to get hold of it? Do you accept that as a risk, that you're generating a new source of crime?
In terms of cyber crime, you mean?
Yes.
Potentially, yes. But it's a risk you have to consider against the benefits that you get from accessing the data. And again, going back to that technical point earlier about if it's implemented in quite a dispersed way, then you disperse that risk. If it was all sitting in a lovely, nice database in Cheltenham or wherever it may be, then in some ways that risk would be higher.
But there is a fascinating tension between one very secure location and a number of potentially less secure locations.
The starting point is that the crime is out there. The crime isn't made by the fact that this is data that can be mined. That doesn't make the crime. The crime is there. Mining the data might diminish the crime. It's that way around.
But Professor Glees, if somebody...
I'm sorry, I need to take time, if we've time, we'll come back to you. Yeah. Baroness Cohen.
Can I start with Dr. Richards? It's suggested that people always suggest to us that whatever regime is put in place, that criminals and terrorists will evade it with the utmost ease. Now, since your background appears to be terrorists, do you think that's right? And if so, is there any evidence that shows that they can evade? Is what I'm after.
Yes, criminals and terrorists are very well aware that they're being monitored. So they're the masters at trying to evade such monitoring as far as they possibly can. And that's happened throughout history. I think the suggestion that criminals and terrorists could easily outwit these sort of mechanisms is greatly exaggerated in my view. The only way to really avoid being monitored by the authorities is not to use any electronic communications at all. That's the only way you can be sure of doing it.
Back to the carrier pigeon.
Absolutely.
Right.
Yes, there are ways, obviously one of the things about the internet is you can appear on it very anonymously. But people have to communicate. They have to use the services that are there. Otherwise, nobody knows who's talking to whom. So I would say there is a limit on how far. Yes, they'll make it as difficult as possible, but they won't sort of make it impossible to be tracked, in my experience.
Could I go to Mr. Wright now on costs?
Thank you, Lord Chairman. we've heard quite a bit of evidence from the Home Office team about costs, monetary costs and benefits of these proposals. I'd welcome your thoughts on them. We've heard estimates that the cost of the draft bill will be £1.8 billion over the next 10 years, and there would be £4.4 billion of net benefits. What do you think of those costs and benefits?
I'm not able to comment, I'm afraid, on that aspect of it. All I would say is that estimates of costs and benefits are always going to be, matters of speculation. That's all I would say. I have no expertise.
Richard, have you got any experience in this?
I would broadly say the same. I mean, the cost, I would say from a technological point of view, the proposals that flow out of this bill are technologically very complex. I mean, to be able to do this physically entails some cutting-edge technology, which probably will cost a large amount of money, and probably in the order of billions rather than millions. Whether it's 1.8 billion, I just couldn't say. I just don't know. In terms of the benefits, again,
we've heard suggestions this afternoon that it would be up to 10 times more than that.
Well, I just couldn't comment on that. I mean, that does seem, if we're talking 18 billion pounds, that seems an extraordinarily high figure to me. Okay. But I just don't know what would be entailed. In terms of the benefits, again, I'm extremely suspicious, excuse me, of any official figures on this. I think it's impossible to put a figure on how much you save the country by winding up criminal enterprises and catching terrorists and so on. We see all sorts of figures bandied about. In the National Security Strategy, it said that the annual cost of the UK from crime is £1 trillion. Now, where that figure comes from and how they've calculated it, I just don't know. And particularly when we're looking at cyber crimes, given that we don't actually know how much cyber crime is actually going on, then how you can put a figure on it, I don't know. So I think this is a very fraught area, and in my view, anyone who gives you an accurate figure is
So you're not aware of any academic modelling that's been done outside of the Home Office or other government departments on the benefits of this type of activity more broadly?
I'm not aware of that, no. In fact, the only academic debate I'm aware of is the fact that you really can't trust any official figures on this.
Well, I do think one policy aspect of cost is that any government, I think, needs to be cautious about private industry trying to sell it software at huge expense that will claim to do the filtering that we've talked about. And I think we are, in our own work, we are aware of the pressures on government from what used to be called the military-industrial complex, the big companies that are very busy wanting to sell stuff. And in respect of that, without trying to put an inappropriate plug-in for our own work at the university, I think there are some things that the state has to do, and I think the provision of security is one of the things the state has to do. And I think the people that need to do this sort of work should be properly employees of the state and trained to do that. And I don't think this is the sort of technical work that should be farmed out, because that would be a huge cost and a huge expense. And to the best of my knowledge, both our security service and the Government Communications Centre are busy trying to recruit the young talent that they think can do this sort of work at the moment, and I think that's the right way to
Professor
approach
Glees, could I take you back to the point you've just made on being suspicious of suppliers willing to supply the sophisticated kit? Now, as I understand it, one can't go to PC World and get a range of this. There will be a monopoly supplier doing a specially designed bit of special kit. And I think we all have experience of Ministry of Defence contracts, which go to double, treble, 5 times the cost, and then the generals always want to add an extra button just before the thing is delivered, putting the cost up again. Have you a view, therefore, on a monopoly supplier of this equipment? Are you suspicious of the cost estimates?
Yes.
Right. Brief short answer, Dr. Richardson?
Yes, and as I said earlier, you're absolutely right that this is extraordinarily complex technology which you can't buy off the shelf. So there are cost implications in that and cost risks for the government, I think.
I mean, on a technical basis, sorry, Dr. Chairman, on a technical basis, I mean, I'm not a technical expert. Presumably this piece of kit will have to interrogate different private sector databases, which may be constructed in different ways. So it's going to have to be adaptable, is it, to a number of private sector organisations' structured databases. Which are changing.
Yes, I mean, my limited understanding is that yes, there's a huge array of different types of data, which is the problem. But the data rates are the problem. The amount of data flowing through the network is extraordinarily high and right at the upper limits of current computing technology. So those are the sorts of issues that you've got here.
Okay.
Mr. Mosley?
Has any assessment been made of how much data will be collected over the period of 1 year?
Not that I'm aware of. I mean, I imagine within the appropriate parts of government, within GCHQ and so on, they would have some sort of estimate of this. Whether that's disclosable, I don't know. I just don't know. I've not seen anything publicly.
Of course, we know the figure for last year, which I think was 550,000 requests to examine data.
That wasn't the question. It was how much data is being stored over this process.
Oh, I see. Right.
I would think that would be known. Obviously, that the telecoms companies themselves know how much data is flowing over their networks, but I don't know. It's a lot.
Dr. Richards, would you be aware of which countries in the world would be capable of making these black boxes and the sophisticated kit?
Well,
no.
I mean, some of this gets into obviously quite sensitive technologies, which I'm not qualified to comment on, really.
Okay,
but there would be a small number of countries that would be
very small number.
Yeah.
We have the capability in the UK, you think?
I believe so. Yes.
Okay.
Yes.
Okay. And Mr. Brown?
Do you believe that eventually there will be an overarching European Union regulatory regime in this area? And do you believe the approach that the last Labour government and the current coalition government are taking, because they're broadly similar, would be compatible with what is emerging from the European Union?
Yeah, it's my understanding that the answer to that is yes. It's a critical area of cooperation with our European partners. Of course, if we could leave the European Union, as some people say, that's something you could throw out of the window. But at the moment, we do seem to be, all of us, talking the same kind of language, subject to the same kind of directives, and underpinned by the same convention on human rights. And that's good.
Yeah.
In my view.
Unless our colleague has got any other question, could I conclude with this one? I think, Professor Glees, you said that, of course, subscriber data is only who, what, where. But as I seem to be learning, it's not actually just who, what, where. It's who, what, where, when, what the details of your bank account, every single thing you may put on your private Facebook account, your home address, everything under the sun could technically be subscriber data. Is that correct?
Now, I'm afraid if I said that, I misspoke. What I thought I said was that what this is about is who, when and where, but not what. So
sorry, my apologies. Yes,
that's now. One may say, well, is it? And I know people in the civil liberties lobby say, if you're looking at who and you're looking at where and you're looking at when, you're bound to also see what. But I have trust in the people we charge to do this, and they say it's not about what.
Accept that. Let's forget about the what. I misspoke there if I said what. What I was trying to get at was subscriber data, as I understand it, is not just who, what, and where. It's not just the person's name and their telephone number. It is a huge range of material, including your bank account number, including all the information you have to give to Mr. Vodafone or Virgin or Facebook or Twitter when you sign up. That is subscriber data.
Yes, absolutely. But again, we know that that kind of data not only exists, but it is most massively exploited, not by any government agency or council or authority, but by the people who sell things to you on the internet.
Yes, that's
it's a fact of life.
Yes, for business purposes, and that's a different question. But can we be clear then that when we say subscriber data is only who, what, where, it is not technically just who, what, where, it is who, what, where, and an awful lot of other stuff?
Well, my concerns are related to this proposed bill, and there it's very clearly stated that this is not about what. Now, one can believe or not believe it as one chooses. I choose to believe it.
Okay, thank you very much. If there's no other questions, thank you very much, Gent. Oh, sorry, Lord Armstrong.
I think I got from the previous session objections from the civil liberties people that the what included so many things that it was tantamount to content. But of course it's the what that gives the authorities the clues that they want to pursue their criminal investigations.
Yes.
I don't know how you have you any thoughts about the point that the chairman makes about the extensive data that are subscriber data and the borderline between that and content.
Well, what the civil liberties lobby, if I could describe them thus again, where they come at this from is the idea of a snooper's charter and a surveillance state. And for them, the starting point is that there is this great bank of data that will be mined arbitrarily and that will affect each and every individual. If you come at this from the point of view of the government and the agencies, this is about particular searches for people who may be involved in serious crime or may be threatening suicide or risk of life. You all know the categories. And there it's about finding out with whom they've communicated, when they've communicated, and where those communications have taken place. But
Which
not
tells
necessarily
you something about what they're talking about.
Well,
or may do.
The what will trigger the specific investigation, but what is being mined is not the content. Generally, it's not a surveillance state operation. It's a targeted operation.
Okay. Any other comments, Dr. Richards? Thank you once again, gentlemen. We've grossly exceeded our time with you as well. I'm sorry keeping you back so late, but thank you very much for, again, an excellent evidence session which we will chew over carefully. Thank you very much. Order. End of the public session. Could I ask all members who are not members of the committee to please leave as quickly as possible so we can have a little private chat. Thank you very much once again.
Committee Room 8, Sound.